And I've got some, yes?
Regarding Mr. Knaus, he's still in the breakout room with Ms. Bauer. I told him.
All right.
Yeah. we're all set.
All right, well, let's take up our next matter. Sweet Lake versus Bennett.
Dana Hall on behalf of Sweet Lake.
No, that's not it. All right, Dana Hull is here. Who's the phone number? Is that you, Miss Bennett?
Yes, it is.
All right, let me. See if I spelled that right. Bennett. All right, Melissa is here from Sweet Lake Mobile Home Park. Dana Hull is here from Swiss Stack Levine Law Firm, and the defendant is here. This is a termination of tenancy. They're alleging excessive filth, damage to the trailer, to the property. I'm not exactly clear. I think this is lot and trailer. Is that correct, Ms. Hull?
I would have to ask the manager. I believe it's just a lot, judging by, the condition of the unit, Your Honor, or are you asking if she owns it, the home?
Well, the rent is, I mean, is this lot and trailer or lot only?
It's lot only.
All right.
I'm sorry, I didn't know if you were referring to the accusations or the
No.
rent.
All right, Ms. Bennett, they want you to move your trailer. This is filed not as a just cause termination, just as a plain old termination of tenancy. You've filed a demand for, or a request for rental assistance with the court. They aren't asking you to pay the rent, although it's a little bit confusing because there's a complaint for non-payment of rent. And then there's damage to health or property. So I could see why you're confused, because our clerk was confused also. But they filed a demand. For immediate eviction on July 15th. The condition of your home is unacceptable due to lack of housekeeping and unsanitary conditions throughout, but not including excessive clutter, trash, mold, dirty diapers. Additionally, upon information belief, your home is infested with bed bugs, roaches, and rodents. Therefore, there are water leaks causing damage in holes of the floor of the home, and you do not have a working furnace. Well, that's lot and trailer. The condition of the trailer is not the park's concern. And then it was filed as a demand for non-payment of rent, and then a demand for possession of property. So we're gonna have to sort this out. At any rate, Ms. Bennett, the law says that you have a right to have an attorney. You can hire one. Let's see what we got here. My girl's phone. And iPhone. All right, someone's logged in as my girl's phone. Who am I speaking with?
Deshavon Moore.
All right, someone else has joined us as iPhone. Who am I speaking with there?
Miss Nichols. Oh, sorry.
Oh, sorry.
Yeah, which case are you, what's your name?
Christina Nichols.
Which case are you here on?
The Vista Meadows.
All right. All right, well, let me advise all of our defendants that you are here in a landlord-tenant matter. As such, you have a right to hire a lawyer. You cannot afford an attorney. Legal aid may be able to represent you, or you can seek other legal counsel. There is no court-appointed counsel in civil cases. You have the right to have the case, you have the right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me here today or file a written demand for a jury trial within 5 days and pay the $50 jury demand fee unless the judge waives the fee for your inability to pay it. I'm really having trouble with my allergies here. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated entry agency, housing assessment and resource agency, that's community action agency, or help for veterans. We sent that information to you with the original packet. You do not need a judgment against you to get that assistance. The summons and complaint are sufficient and you have received that. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can help set that up. And finally, if the matter can be resolved with an agreed upon disposition, it could be filed a conditional order of dismissal, and the attorney would help prepare that. Give me just a minute. I'm fighting my allergy here. Last thing anyone wants to do is watch somebody blow their nose on a live stream, but all right. Let's go back to your case, Miss Hall. It's got 1 foot in 2 different arenas. I'm not sure if it's a lot and trailer, lot only. Miss Wing says it's lot only, but they're invading the interior of the unit. What are we dealing with here?
Your Honor, could I have a breakout room with the attorney, please?
With the attorney?
Yeah.
Okay, Miss Wing. Problem is, Meg Bauer's in there right now.
Oh.
All right, so let's hold on a minute. We can skip ahead to the next one. Mr. Bradshaw, would you join us? Colonial Estates versus DeShavon Moore. Mr. Bradshaw may be in another hearing somewhere else. His office is very busy.
Okay, there you are.
Well, we're stuck. The breakout room is in occupation. Mr. Bradshaw is in probably another jurisdiction.
No, I'm right here. Sorry.
Oh, all right, we're ready to address your case.
Yes, I was giving the client, sorry, giving staff the dismissals.
All right, well, let's talk about Colonial Estates versus DeShavon Moore. File number is 251692 LT. Ms. Moore was advised of her rights. This is a non-payment of rent case. Rent is $9.25 per month. What's the current arrearage?
Yes, the current amount due through the month of September is $2,010. Court costs are $200.50 for a total due through September of $2210.50.
Ms. Moore, do you agree with that?
Yes.
What's your plan, to try to get caught up or move?
We are trying to get caught up. We've been making payments every week.
Good. All right, the law says I need to continue this matter at least 10 days. So I'm going to continue this to 10/40 on 9/19. So how much you're paying extra each week?
Around 600 to 700.
Well, hopefully we can do a conditional dismissal, Your Honor. Try to get it.
Yes. If this sounds like you've got a good plan to catch up, they can do a conditional dismissal and take this off your record. I'm going to close the breakout room. I don't have the luxury of leaving them in there. Because I need it for the other cases. But Ms. Bradshaw, Mr. Bradshaw, perhaps you could contact Ms. Moore and discuss that. So I'm going to have you get her phone number.
Yeah,
And then,
I'll grab her phone number and her contact information and jump back out.
all right. I can open more than one breakout room, but every time I do, I get sideways. It causes audio problems and other. All right, Mr. Knaus is done. Good luck, sir.
Yep, thank you.
I'll see you next week.
Yep, I'll be here next Friday, 10:30.
Okay. Now,
Are we done?
yeah, we're done.
Oh, okay. Just
Ms. Moore, I'm gonna put you and Mr. Bradshaw in the breakout room. And
Excuse me. I'm having horrible allergies as well.
I'm not sure what it is. All right, let's try this. D. Moore and J. Bradshaw. All right, this will take just a minute. And then Miss Wing, I can put you in. So hit the button that says join. So Miss Bennett, just stay with us for a minute.
Okay. Thank you.
All right, we're gonna get caught up a little bit. We're on hold here due to logistical issues, but our 9:30 case is entitled Colonial Crest Apartments versus Reese. Mr. Bradshaw has submitted an order of dismissal in that case. without prejudice. Now, Mr. Shalom is here on a case I don't have on my docket.
Yes, Your Honor, I think it's my mistake. I think you have this case actually up September 15th at 9:45, and somehow my office told me to come today.
I think it's set for Monday.
Yeah, Monday.
All right. Well,
Sorry, Your
I'll
Honor.
see you Monday then. Thank you.
Oh, okay, thank you for the confirmation.
Okay,
Appreciate it.
thanks.
Goodbye.
All right. Miss Moore, you're good to go.
Okay,
I'll
thank
through-
you.
All right, Mr. Bradshaw, I did your order of dismissal in Colonial Quest versus Reese.
Great, thank you so much.
And I think that finishes your obligations with me this morning.
It does. Thank you so much. Have a good week.
All right, we're still working on Sweet Lake versus Bennett. I'm gonna utilize the breakout room and put Attorney Hall and the manager in that breakout room. All right, you should be able to join. Meg, you didn't hear this case. You were in the breakout room. It's Sweet Lake versus Bennett. It was filed as a non-payment of rent in July. Then it was filed as a demand for possession for hazardous property. And the defendant has asked for or sought financial assistance. So the complaint is for non-payment of rent. The rental rate is 0. And then they've got a demand for possession for hazardous property. So the thing isn't pled correctly. And they're alleging, and I'm also told it's lot only, but the notice has to do with stuff inside the trailer, bed bugs, dirty diapers, and so I'm unclear as exactly what our posture is. So I raised that, and then Ms. Wing said she'd like to speak privately with the attorney.
Oh, is Ms. Wang with Sweet Lake?
Yes.
I see. Okay, okay. Thank you.
All right, I've got a 940 and a 950. Future Investments LLC versus Yvonne Briggs. Mr. Cromendike is here. And Mr. Heinrich is here. Miss Briggs is not. This is file 25179A. Good morning, Mr. Cromendike.
Morning.
Mr. Heinrich. This is a termination of tenancy for a property on E Street in Mendon. It was served by attachment. There is no lease, and the defendants are not here. Yeah, we have a second mailing, so I guess we could do a default. Make a note here. This is filed as a termination of tenancy. Doesn't sound like this property is in very good shape. Mr. Heinrich, is anybody in there?
Yes, we believe that she is still in there.
Mr. Cromendike, what's your proposal?
We'd request a default judgment.
I'm gonna check with the bailiffs. One time last week, I didn't check and the person was actually out in the hall. We have a very busy morning this morning with lots of customers. Hi, I'm looking for Yvonne Briggs. Yes. All right, thanks. We have a number of people that are in criminal cases and sometimes people get confused and anyway, she is not here. I would grant the default. 10 days from today is September 22nd. No money judgment. I would ask that you would email me a judgment at our address, 3B Civil at ST Joseph County mi.gov.
I will do that.
Let me wait a minute to hear back from the bailiff.
Yep.
We have Enchanted Glen at 9:50. And then we're gonna shift gears to some civil matters at 10. Apparently, the defendant is not here. I haven't heard from the bailiff. So the proof was by attachment. There is a second mailing which entitles the plaintiff to ask for a default judgment. Plaintiff believes she's in the property. It was served by attachment. She is not present. All right. 10 days from today is the 22nd. The next day you can ask for a writ of eviction.
All right. We'll get that judgment submitted.
Thank you.
Thank you.
I have two vehicles in the driveway of this property. It's a dumpster in front of the vehicle, so I cannot move my vehicles until that dumpster is moved. I was told by Miss Faith Shepherd that I would need to move my belongings first, and then she would move the dumpster. But of course, I don't feel comfortable with moving my possessions until I can move my cars.
All right. What date were you planning on moving?
Sometime this coming. So
this coming when?
Excuse me, Your Honor.
Go ahead.
Yeah, I was planning on getting a pod to put all my belongings in this coming week, and I just need to move my cars as well though. But
I understand.
Yeah.
All right. So you're gonna move this coming week. I will adjourn the matter out to the 19th, 2025 at 2 p.m. That's an in-person hearing. So if you haven't vacated the premises and turned over the keys, you need to appear in person. And Ms. Gazzari, if you could talk to your client about moving the dumpster.
Yes, we'll do.
All right. Fantastic. All right. Thank you, sir.
Thank you, Your Honor.
Court does call the case of Strong Future Homes versus Veronica Webster.
Carissa Gazzari for plaintiff.
Veronica Webster, and also, or Aaron Hayes. Webster, Hayes, they're not here. If you'd like to take default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
All right, go ahead.
Thank you, Your Honor. This is an action for termination of tenancy. Defendant's tenancy was terminated.
Is it?
pursuant
Hold on.
Okay.
I have it as a non-pay. It is a termination. I see it. They just marked it wrong. Go ahead.
Okay, thank you. Defendant's tenancy was terminated pursuant to a 1-month notice to quit. There are details in the notice regarding the violations. Since the notice to quit was sent, there's been further disturbances and continuing police activity. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days.
Judgment to the plaintiff. That is by default for possession. Redemption. There is no redemption amount. Rich issued 10 days.
Thank you, Your Honor. Have a good day.
That's it for you guys. That's weird. Anyway.
Thank you.
Yeah, take care. MDPP LLC, AK Jacob Roberts versus Quinrita Bryant. Ah. And also Keena Bryant.
Hi there, Your Honor. Jake Roberts.
All right, and do I see I see both Bryants. Okay, they're both here. All right. All right, what is plaintiff's claim in this case?
Past due rent totaling $1522.78. We are requesting payment and a default judgment for possession.
All right. So the total amount, including your cost, is $1522.78.
That's correct, Your Honor.
All right, folks, what do you have to say about that? When can you get that paid?
Okay, so number one, I disagree with the amount based on the way that it was charged. But as far as a lot of that is for some fees and whatnot that I feel are incorrect from last month. Long story short, Okay, so what happened was I had a return check, but it wasn't from non sufficient fees. It was R03, which means that something could have went wrong in the system, etc. I put the same exact payment in and then it went through. But in the midst of that, he started charging these extra fees.
What extra fees?
He charged late fees and insufficient funds, but the return payment was not due to insufficient funds per the bank code.
All right.
And so that's really where we are with like 300 or whatever is per last month of those fees. And the other part is for this month, which I will be able to pay by the end of this month. But I do disagree about the fees.
Let me ask you this. How much do you think you owe? You think you owe the 1522 less about 300?
I feel like I owe the 1,050, which is the rent for this month. For September, which this case is not about, plus whatever late fees for this month.
This case is about September. So you owe. So how much of the 1522 do you believe you owe?
So today being the 12th, that's 120, 150, 1170 or 1180.
Okay. And all right. What are these other fees that are being requested by you? Can you break down the 1522 for me, please?
Yeah, not a problem, Your Honor. So these stem back to late fees starting from August 20th. There's a $10.
How much are the late fees?
I'd have to total them due to the fact that it's $10 per day since the 20th.
That you cannot charge that.
Okay.
You cannot charge liquidated damages, which that would be. That is an excessive late fee, and this court won't enforce that.
That's fine. Yeah, that's fine.
All right.
Reverse payment fee. So when you reverse your payments, and then court costs, which are $178.80.
So how much are you claiming is owing in rent?
Sure. In rent owed as of today, it is $10.85. And then the late fees, have on top of that. That's where the 15 comes in, plus the court costs, plus the reverse payment fees.
How much is this reverse payment fee?
$35. Which last month we've had 3 reverse payments.
And I've paid the late fees for those, which were correct. But this one was not insufficient funds. It was something inside of your portal that you use Buildium, because I literally submitted the exact same payment and then it went through. It's saved in the portal and I literally resubmitted and it went through.
Your Honor, we've had a reverse payment on 7/1, reverse payment on.
I understand that you may have had that. I think she's claiming that it's a problem with the portal as opposed to her account.
Yes.
Go ahead.
Yes, Your Honor, because
okay, ma'am,
different.
I didn't ask for an explanation at this point.
Sorry.
All right. So let me ask this, ma'am. By next Friday, how much can you pay?
By next Friday, at least half. I can have the full amount by the end of the month.
I heard that the first time. I was asking about next Friday. How much
At
can
least
you pay?
half. At least half. So we'll make 600, so a little bit more than half.
All right. You need to do that by the 19th. I'll
Okay.
adjourn this matter out to September 19th. You're entitled to the adjournment. September 19th, 2025 at 3 p.m. That is an in-person hearing, so I'll need all of the parties here at the courthouse.
Thank you.
Thank you. Court does call the case of Jeffrey, was Zoric, doing business as Yvonne Davis versus Michael with Zoric.
Hi, Your Honor. My name is Yvonne Davis. I'm the guardian for Mr. Jeffrey Warzik.
You're the guardian. Okay.
Until Thursday.
Here, okay, we're gonna have a bit of a problem here, but I think we can get past it, maybe. You're not are you an attorney, ma'am?
No, I'm not, Your Honor.
Okay. Then you're gonna need somebody actually to represent the interest of Jeffrey.
Okay.
You, while being the guardian, you can't do that in court, if that makes sense to you.
It does. I have an attorney, so I can collaborate.
So what I will do, this is a termination. Is this based upon the expiration of a lease or?
No, Your Honor. Mr. Warzik, Michael Warzik, is still living in the property, and Jeffrey is living in a nursing home, and we need to sell his assets. And his house is going up
Understood.
the
I
auction.
got you. Okay, I got you. Was there a lease on the premises?
No, I don't know. My client.
No, Your Honor.
Okay. All right. So here's what we'll do. First of all, plaintiff has to have an attorney. All right. I will adjourn this matter out to September 19th, 2025 at 3 p.m. That's an in-person hearing. I'll need parties here and see if we can get.
Councilman C. Mr. Savage is here on behalf of the Law Director's Office. And we're scheduled for a change of plea in this matter today. Ms. Borst, is it your wish to change your plea to guilty to the falsification charge?
Yes.
Okay. You understand that a guilty plea is a complete admission of your guilt?
Yes,
Did you sign this change of plea form?
I did.
Did you understand it?
I did.
You understand by pleading guilty today, you're waiving your right to a trial, either to a jury or to the court.
Yes,
Did you sign this waiver of jury trial form?
yes, I did.
At a trial, you'd be able to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights today?
Yes,
You also understand you're giving up the right to question any witnesses the state would have against you.
yes, I do.
And finally, you understand you're giving up the right to have the state prove beyond a reasonable doubt you did in fact commit this offense.
Yes, sir.
And Mr. Savage, I'm going to have you go ahead and tell me what happened here. Recite the facts for me, please.
Your Honor, this is regarding a stray animal admission receipt with the Licking County Dog Shelter. The defendant brought in what she claimed verbally and on the official paperwork to be a stray dog that that she swore never belonged to her, her family, or any other acquaintance, and that she had no information regarding the ownership of said dog. The dog wardens, following a examination of her social media, found that that was not the case, and that is the basis for the charge today.
Thank you. Based on that, I'll accept Ms. Board's guilty plea as being voluntarily and intelligently made, knowing what her rights are, found guilty of falsification. State have a recommendation.
Fines and court costs, Your Honor.
Okay. Ms. C.
Thank you, Your Honor. Ms. Forrest does accept responsibility for her actions in this matter. The issue with the dog has been all worked out. And she does not have the criminal history other than, I believe, a couple minor charges. We would ask just for fines and costs today. Thank you.
What happened with the dog?
I still have him. They made me put him in my name. The only thing I lied about, Your Honor, is how long I had the dog. He really is not my dog, but he is in our name now.
So you registered the dog?
I did.
Okay. All right. You want to say anything today?
No, that's all I have to say.
Okay. How long did you have the dog?
I don't remember, honestly. I knew it was still cold out, and I took him in on April 22nd. So, and she found him on my Facebook April 1st. I did try to find its owner because he was dumped on my street.
Okay.
He was small. I mean, he's bigger now, but he's mean, and I have kids. So I tried to turn him in as a stray, and
Gotcha.
I signed the paper. I had him less than 3 days, and that's what I lied about.
Okay.
So,
Gotcha.
yeah.
Okay. Well, I've been getting a lot of these. And
We have 2 other dogs, so, and they're registered. So.
yeah. Well, that's good.
Yeah.
You know,
I didn't want to dump him on the street like somebody else did.
I understand.
Yeah.
Okay. Okay, $75 and court costs. Thank you.
Thank you.
This matter resolved.
Yes,
Okay.
Your Honor. Yes, Your
Okay,
Honor.
sure. All right. Thank you.
Thank you.
Thank you. I love you.
State of Ohio versus Derek Snipes. Mr. Snipes is President of Council. Mr. Bodike. Correct. And Mr. Savage is here on behalf of the Law Director's Office. Mr. Snipes was in for a pretrial conference this morning and appears he has 2 outstanding warrants for failing to appear with Judge Stansbury. Mr. Bodike, you care to address that item, please?
Yes, Your Honor. Thank you for having us here. We do appreciate it. He did fail to appear twice, but there was a misunderstanding. He is in treatment. He left the address that he had of record. He did not have a working cell phone for the past few months. He has been compliant with treatment. He's living in the Allen house. He's been very successful for the last 2 months. He also has diabetes. He needs his insulin. We're asking for a PR bond to get him out today. I believe the state does not have an objection.
That's correct, Your Honor.
All right, well, Mr. Snipes, you're gonna report downstairs before you leave today for your probation. Obviously, you don't wanna miss another hearing.
Absolutely not.
Okay.
Absolutely not, sir.
You know, Judge Stansbury's gonna keep you in jail on these, and I'm gonna revoke your probation, so let's not do that.
No, that won't happen.
Okay. Thank you.
Sorry.
14A stands in recess.
Does not vacate. P35797 appearing on behalf of the plaintiff.
They are not checked in. Downey? Have no response. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Go ahead, sir.
Thank you, Your Honor. Based on my client's books and records, the current rent to retain for Ms. Downey is $1,724.50. Costs are $175. So we're requesting a possession judgment in the total amount of $1,899.50 with an order of eviction to issue after September 22nd if said amount is not paid or if the tenant does not vacate the leased premises in the interim. To the best of my knowledge, Ms. Downey is not incompetent, a minor, or a member of the military service.
Judgment to the plaintiff. That is by default for possession, redemption amount, any amount requested with the writ issue in 10 days. Arbor Meadows versus Thomas Miller.
Daniel Landman for the plaintiff. I believe Mr. Miller was present.
Yes, and I have a note here, and I'm going to pass it. And I have a note here that said he was having Zoom difficulties and that he was coming to Zoom in from the courthouse. So he's not here yet. So I'll pass it and let's see if he shows up.
Thank you, Your Honor.
Augusta Woods versus Sean Brown. Sean Brown, not checked in.
Daniel
You may
Landman for the
proceed.
plaintiff. Thank you, Your Honor. Your Honor, based on the books and records at Augusta Woods, the current rent to retain for Mr. Brown is $2,239.50. Costs are $179 for a total of $2,418.50. The proposed possession judgment provides for a writ date of September 22nd. To the best of my knowledge, Mr. Brown is not incompetent, a minor, or a member of the military service.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested with the writ to issue in 10 days. Augusta Woods versus Papa Gaye. Papa
Daniel
Gaye.
Landman for the plaintiff, Your Honor.
Gaye, no response. You may proceed.
Thank you, Your Honor. Your Honor, based on the books and records of Augusta Woods, this tenant's rent to retain is $809.43. Costs are $179 for a total of $988.43. The proposed judgment provides for a writ date of September 22nd. To the best of my knowledge, this tenant is not incompetent, a minor, or a member of the military service.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Augusta Woods versus Susan Wolf.
Daniel Landman for the plaintiff, Your Honor. Ms. Wolf is present.
Yes. Ms. Wolf, can you unmute? Okay. Oh, I don't think we can hear you. No, still can't hear you. Okay, while you work on that first, well, I'm gonna need to hear from you. All right, while you work on that, and Mr. Wolf, what you may want to do is you may want to sign off and sign back in. All right, I'll pass your case. And then sign off, sign back in and see if that helps. Just pay attention to the information regarding audio. Okay? Thank you. Augusta Woods versus Paul Reedy and Nella Reedy. Well,
Daniel
Paul Reedy.
Landman for the plaintiff. Mr. Reedy was present. There he is.
He's
Just needs
here.
to zoom to unmute.
I think that's it.
Okay. Mr. Reedy, we got to quit meeting like this. All right.
Welcome back. Yeah.
All
Sorry.
right. No, it's all right. What is plaintiff's claim?
Your Honor, plaintiff is showing rent to retain of $373.83 and costs are $218. So the grand total is $591.83.
All right, Mr. Reedy, how are we going to get that done?
Okay. I've been trying to get it straightened up. Was close to getting it straightened up. I paid $1,100 on the 3rd. Then my truck broke down. I bought a used truck, and the warranty that I purchased, of course, didn't cover corrosion for my exhaust manifolds. So that's in the shop getting fixed. I'm like, man, it was $288, and then the late fee, and then the court fee was like, oh my gosh. Anyways, I called the lawyer's office yesterday, and they said they didn't see my name, so I was hoping it was like a dismissal or something. But I'm just trying to find out if there's any way I could work with them and get everything totally paid on the 3rd when I get my check. I've been saying that, but then it's like something happens. I don't owe a ton. And I'm close to being good, but man.
No, I got you. Let me ask you this. Between now and next Friday,
Armstead, how old are you?
34.
How far did you go in school?
I graduated high school.
Were you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No.
Are you a United States citizen?
Yes, sir.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What I'm going to do is we're going to conduct a level 2 pre-sentence investigation. I'm going to set this for sentencing in about 8 weeks. I have a lot of these types of cases come through my docket, Ms. Armstead. I used to put everybody in jail for 90 days who tried to convey drugs into the prisons or jails, any of the community-based corrections facilities, any of those sorts of things. I found over time that did not it wasn't particularly effective because most of the people that I have on my docket who do this kind of thing never do it again. So my plan would be to put you on probation, give you rules to live by, and make sure that this doesn't happen anymore. Also keep you off the grounds of any detention facilities. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. Looks like on the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. McKenna before you signed it?
Yes, I did.
Are you satisfied with the representation
Yes,
that
I
you've
am.
received in the case?
Yes, I am.
You're going to enter a plea of guilty to one count of illegal conveyance of drugs of abuse onto the grounds of a specified detention facility or government facility. It's third-degree felony, punishable by up to 36 months in prison and a $10,000 fine. If you violate the terms of your supervision and I do have to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're
Yes, I
presumed to
do.
be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it.
we're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on March the 7th of 2025 at the Warren Correctional Institution, a detention facility located in Warren County, state of Ohio, that prison investigators had intercepted telecommunications between the defendant and co-defendant inmate Michael Warren, indicating that she was intending to convey drugs into the prison. On the following day, she had a scheduled meeting with inmate Warren for a visit. She was intercepted after having passed into the prison, confronted regarding the conveyance, and she produced and turned over to investigators a package that contained 50 strips of buprenorphine, a Schedule III controlled substance.
Any of those facts, Mr. McKenna?
Yes, sir.
Ms. Armstead, did you hear those facts?
Yes.
Do you admit they are true?
Yes.
Do you understand the right you're giving up by entering a plea?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. You need to go back down to pretrial services, fill out the paperwork for the PSI. This I will get us a date for sentencing in about 8 weeks.
Thank you, Judge.
All right, that's all.
Thank you, sir.
How much do you think you can pay?
I hate to say that I can pay it and not be able to pay it, but I'm gonna do whatever you say to do, you know.
Well, I'm asking you, how much do you think you can pay between now and then? You're not that far.
I'm not sure. Hopefully at least a couple $100. I know it's more than
All right.
that, but
What I'll do is I'll just put a couple hundred here, somewhere by the 19th, and I understand what you're telling me. I'll adjourn this out to September 19th, 2025 at 3 p.m. All right, that's an in-person hearing, and then contact the attorney's office or the management and see what you can work out.
okay, I appreciate you. I appreciate you, sir. Thank you very much.
All right, take care, sir.
Have a good day.
You too. Augusta Woods versus Colette Drew. And
Daniel Landman for the plaintiff, Your Honor.
And Calvin Turnage. Drew, Turnage, neither are here. You may proceed.
Thank you, Your Honor. Based on my client's books and records, the current rent retained is $894.31. Costs are $218 for a grand total of $1,112.31. The proposed judgment reflects a writ date of September 22nd. To the best of my knowledge, neither of these individuals are incompetent minors or members of the military service.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with the writ issue in 10 days. I think Ms. Wolf signed back in, so let me try that again. Augusta Woods versus Susan Wolf.
Daniel Landman for the plaintiff. I do see her name.
Yeah.
I don't see her.
I don't, yeah. Did she signed off though?
Yes, correct.
There she is.
All right. Ms. Wolf? Yeah, no, something's still wrong with that. All right, let's see what we can do. How much is owing?
Your Honor, based on my client's books and records, The current balance is $969.21. Costs are $179 for a total of $1,148.21.
All right. Okay, since I can't hear you, it's okay, Ms. Wolf. Since I can't hear you, is there, I'm gonna ask yes or no questions, kind of, all right? Is there anything that you can pay by the 19th? Well, you're talking, but I can't hear you. Is that a yes or no? That was neither. All right, maybe I should do this. Ms. Wolf, can you hear me? Well, I need, nod your head if you can hear me. Okay. Can you pay anything on the balance before the 19th next Friday? Just give me a yes or no. No? Okay. So here's what I'm going to do. If you need assistance, you make sure that you pay attention to the video that played. I'm going to adjourn this for an in-person hearing to September 19th, 2025 at 3 p.m. You'll need to come down to the courthouse and then we'll deal with it there. And presumably I'll be able to hear you on that day. Okay? All right. Thank you. Have a good weekend. Did Mr. Miller? Oh, he's popped in. Let's go back to that one then. Arbor Meadows versus Thomas Miller.
Daniel Landman for the plaintiff. I do see Mr. Miller being in the Zoom meeting.
Hello, Your Honor.
Hello, Mr. Miller. Can you turn on your camera down there, or?
I'm here in the court learning the laptop here. My phone
Okay,
was,
it's all right.
Oh, there
We
he is.
got you. There you
my
are.
phone wasn't connecting. It connected, kicked me out, connected, kicked me out. So I figured I'd
No,
call the
it's-
number and get up here.
It's okay. We got the message that you were having problems and you're coming down. So appreciate you doing that. All right, how much is owing on this?
Your Honor, my client's books and records reflect a balance of $2,202.60, costs of $175 for a grand total of $2,377.60.
Your Honor, that would be as of October 1st. It's not October 1st yet, so that next month is not due.
Let me check that, Your Honor.
Hold on a second.
I only owe for
Hold on,
September.
hold on, Mr. Miller.
Yes.
Your Honor, the ledger is reflecting that that's owed through September. It does not include October.
No. I'm only 1 month behind.
You're 1 month behind for,
September, sir.
you think you paid through August?
I would have to jump into my receipts, but I'm only expecting $1,123.73, I believe.
That, Your Honor,
And
was
that's
the
what
amount in August without
Your Honor,
including the numbers run.
I have the court paper here of the number is 1,123 on the court paper. It's not.
I gotcha. No, that, and those court papers, let me just double check, would have been filed with your August balance, because those were filed in August. And now September's due. All right.
I can't
Let me ask
argue
you-
without my records, without the receipts. So
Okay.
I was
So-
only
Between now and next week, how much can you pay?
I have 300 in my pocket. I've had to pay everything else due to medical problems between my wife and myself. I've been unable to work. And she can't work because they won't hire her.
All right.
But I have 3 degenerative discs, so there's times that I can't even walk, Your Honor. And I've been, this last year has been really bad. I've been working with some dermatologists, rheumatologists, and all this to get me to where I can manage I've got psoriatic arthritis, which is also psoriasis. So it's really
Got
hard sometimes. This is why you see me a lot, is because sometimes I can't hold up to my responsibilities, but it normally doesn't take me very long to come back.
Okay. So here's what I need you to do. And let's see what we can work out. Pay the 300 to your landlord today. And then I'll adjourn this out to September 19th at 3 p.m. That'll be an in-person hearing. So you need to come down to the courthouse like you did today, but you get to come into the courtroom. Okay?
Yes, sir. Thank you, Your Honor.
All right. We'll see what we can do. All right. Take care. Beal Properties versus Jacqueline Poole.
Daniel Landman on behalf of the plaintiff.
Jacqueline Poole. Not here. You may proceed.
Thank you, Your Honor. Your Honor, based on my client's books and records, Ms. Poole's rent to retain is $1,928.73. Cost her $175 for a grand total of $2,103.73. The proposed default judgment for possession provides for a writ date of September 22nd. To the best of my knowledge, Ms. Poole is not incompetent, a minor, or a member of the military service.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Beal Properties versus Mohammed Ahmed.
Daniel Landman for the plaintiff, Your Honor.
Not checked in.
Mohammed Ahmed, not checked in. You may proceed.
Thank you, Your Honor. Based on my client's books and records, the rent to retain for Mr. Ahmed is $2,270. Costs are $175 for a grand total of $2,445. The proposed default judgment for possession reflects a writ date of September 22nd. To the best of my knowledge, this tenant is not incompetent, a minor, or a member of the military service.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days.
Thank you, Your Honor.
Thank you. Augusta Woods versus Jessica Phillips. That matter is dismissed on plaintiff's motion without prejudice. All right. Thank you, sir.
Thank you, Your Honor. We'll see you this afternoon.
Yes, sir. Clark Road Family Dividend Housing versus Tajari Baker.
It's Dejanay Baker, Your Honor.
Say it again.
Dejanay.
Dejanay. Okay, I get it right today, but I'll mess it up next time. I guess.
Okay.
All right.
It's hard.
Okay. All right.
Good morning.
Counsel.
Good morning, Your Honor. Attorney Samantha Sprague, 1931, appearing on behalf of the plaintiff.
All right. And what is plaintiff's claim in this case?
Yes, Your Honor, we do show that currently there is past due rent in the amount of $2,779.23, along with court costs of $239.40, for a total due owing of $3,018.63.
All right. And Mr. Baker, how are you intending on getting that paid?
Your Honor, at the moment, I do not have the money to pay that.
Okay. Have you sought out any assistance at all?
I have. Your Honor, thank you for allowing me to speak first and foremost. I'd like to explain why I stopped paying my rent in July. It was not made lightly. It was due to my landlord's repeated failure to uphold their responsibilities under the lease and maintain a premises in a livable condition. There were even problems prior to my move-in. The original lease that I signed on date of January 24th, but the complex changed that date to January 31st. Without my consent, even with the new date, I was still required to pay a proration rate of $550. On top of that, I didn't sign an official lease until March 6th, which caused confusion about my rights and my obligations. Most recently, I came home to find a leak in my ceiling that caused a large hole in my apartment. The water damaged my new sectional, my television, and resulted in the death of my pet gerbil. The hole is still present and the leak was never properly resolved. The situation made my apartment an unlivable.
Did you tell the landlord you had a leak?
Yes, I did. I had called them that same night, and the maintenance director came to my apartment that night and discussed with me a few more issues that was going on in the apartment complex, as far as the shooting that had just happened the day before, as well as other problems with tenants having the water leaks in their apartments. It's black mold growing in the building. There is a tenants union that's trying to pursue a civil lawsuit against Huron Vista about the problems that
All right, here's what I'm gonna do. I'm gonna stop you right there. I'm gonna adjourn this out to September 19, 2025 at 3 p.m. That's an in-person hearing. You'll need to appear. I will reserve from this date the issue of escrow in this matter. You'll need to file a written answer with the court detailing what your complaints are. You'll need to do that by September 18, 2025. You need to send a copy to the attorneys for your landlord.
Okay.
All right, we'll see you next week in person. Thank you. Clark Road, I'm sorry,
I'm so sorry. If I could get the date that written statement is due from her so I can calendar that.
the 18th,
The 18th. Thank you very much.
yes. Clark Road Family Dividend Housing versus Lazaria Daughtery.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Daughtery, they are not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right, go ahead.
Your Honor, I do show that there is past due rent due and owing in the amount of $2,626.70 per my client's ledger. Additionally, there is court costs in the amount of $239.40 for a total due and owing of $2,866.10. To the best of my knowledge, the unit was kept fit and habitable for its intended purpose. The defendant is not a minor in the military or otherwise unable to attend today's hearing. We did request a money judgment.
Oh, did you?
And
okay.
I could, my apologies, Your Honor, I don't have that proration, but I will get that in just a moment.
And I do have personal service.
Yes, Your Honor. I do show that their rental rate is $1,588 prorated to today's date. That would be a reduction of $952.80, which brings us to a problem with my Excel spreadsheet that is locked on me. If you can give me just a moment. My apologies to the court.
Okay.
That does bring us to a reduction in damages to $1,673.90, along with court costs in the amount of $239.40 for a total money damages in the amount of $1,913.30.
All right. Judgment to the plaintiff, that is by default for possession. Redemption amount is the 2866.10 figure with the writ to issue in 10 days. A money judgment in about a 1913.30 will also enter.
Thank you, Your Honor.
All right, thank you. Valley Ranch versus Sharia Caldwell.
Hi, Your Honor.
Hello. What's your name?
Sharia Caldwell.
This is very unusual. Ma'am, do you think you paid your rent?
So what happened in my situation was for the month of August, I tried to go into the office and give them the cashier's check, but they told me that they were no longer accepting cashier's checks for whatever reasons within our company policy that had changed. So at that point, it was mid-August. They have filed in court And so the late fees, the court fees was an additional almost $700.
No, I got you.
Yeah,
No, I'm trying to figure out, usually these attorneys are here. And so I'm giving them some latitude. Can we call their office? All right, ma'am, I'm gonna stand in recess a bit and then I'll come right back. You're all I've got left, but I don't know where the other side is, okay?
Patty. Thank you, Your Honor.
Thank you.
Right, looks like the moment.
Okay.
Oh, from
Recall the case of Valley Ranch versus Caldwell.
Thank you, Your Honor. Rachel Dornbush, Palace Law, on behalf of the plaintiff.
What is plaintiff's claim in this case?
And Your Honor, we have a total due with court costs of $4,954.36.
All right. And Ms. Caldwell, how are you intending on getting that paid?
Hi, Your Honor. So I was mentioning before that I tried to come into the office to pay with the cashier's check for the month of August. However, I was told that they no longer accept the cashier's check. And that when you try to pay online using your debit card, it was an additional $100 and something that I didn't have. So what happened was, after mid-August, once they said that they wasn't accepting my cashier's check, the court had the fees and the late fees, the court fees had already been filed and added. So at that point, I couldn't afford that piece of it. In between time, in additional, what was happening as well is that the second bedroom, we've been having issues to where it's been flooding like the entire bedroom. So now I believe there is mold growing around the baseboards of the second bedroom. So right now, my goal was to work with the property management company because of the mold from the issues of, I believe it's like a foundational issue because we're kind of like right off the pond area. So when it rains and we're garden level, it's the whole entire second bedroom gets flooded out. So at this point, I wanted to work with the property management company to see what the options were.
All right, here's what I'm gonna do. I'm gonna order that you, if you've got what you claim are repair issues, I need a written answer to the court by September 18th, next Thursday. And you need to send a copy to plaintiff's counsel.
Understood.
Thank
All
you,
right.
Your Honor. And just so the court's aware, and when I spoke with my client, Your Honor, the person who I spoke with was unaware of the issue that Ms. Caldwell raised, but it looks like she did submit some maintenance work orders. Sounds like she informed the leasing consultant that she didn't intend to pay this month's rent, but that she intended to put the rent in escrow. So with that being said, would the court entertain an escrow order today?
I will, particularly since there was an indication that the payment for August was attempted to be paid, but was not paid. So how much is the monthly rent?
It is $2,055, Your Honor, and then there are utilities, water, sewer based on usage. There's a static trash fee of $5 and a service fee of $4, but the water, sewer themselves are based on usage.
Got it. All right, ma'am. Since you're saying to pay your August rent, I'm gonna order that August rent be placed into court escrow. All right. That means you have to come to the court and you have to pay that into the court. You need to do that within 7 days of today's date. I'd suggest you do that by the 18th.
Understood.
And Your Honor, the total amount that was due for August, so the court is aware. I'm just taking out the court fees. Give me one moment.
Okay.
Total charge for August was $2,260.60. That includes the water, sewer, trash, and service fee. And then the September charge, 79.34 plus 65, 74. The September charge is 2209.08, and I can prorate that if the court desires.
Please do.
Times, what do we have? 18 days left. All right, looks like the September charge would be 1325.45.
All right. So 2260.60 and then 1325.45.
2260.60 and then 1325.45.
Okay. All right. Ma'am, I need you to deposit with the court. I'm going to order escrow at this time, given what you've said regarding the rejection and payment and everything. So you'll need to provide to the court. Let me try to do my math here. Or paid to the court, $3,586.05.
And Your Honor, I can
Got that,
prepare an
ma'am?
order to that effect, and I'll indicate that if this case proceeds into any additional month, that it would be due within the ordinary course.
Yes, ma'am. That'd be fine. All right. So I need that within 7 days of today's date, okay? Ms. Caldwell?
Thank you. Thank you, Your Honor.
All right. And so that you're aware, that amount would need to be paid to the court in cash. Okay?
Gotcha.
So that there's no misunderstanding and you come all the way up here with that. I will then adjourn this matter to September 19th, 2025. Ms. Caldwell, that's an in-person hearing at 1 p.m.
Thank you, Your Honor.
All righty. Thank you.
Thank you, Your Honor. I think that was the only matter other than the one dismissed matter, and we thought our docket was resolved, so I apologize.
Oh.
And as soon as I saw Ms. Weidling had called and her reason, I jumped right on, so.
Well,
I appreciate
and
the court's
appreciate Ms. Caldwell waiting because I said they normally show up. So that's why
Thank
we
you,
waited.
Ms. Caldwell.
And actually, I'll tell you what I said. I said, I'm not blaming Ms. Dornbush for this at all. I'm blaming it so that you can tell her I'm blaming it on Ms. Mattson.
Well, Ms.
just-
Mattson will be signing in for the noon docket. I'll be sure
All
to
right.
prime her, Your Honor.
Okay, you make sure to tell her that it's all her fault. Ms. Caldwell had to wait. All right.
I absolutely will pass the buck on that one.
All right.
Thank
You
you.
guys take care. All right.
Thank you.
Thank you. Court stands in recess.
Vista Point 6, what's this one? That's from last February. We had another one.
Yeah.
I don't know what happened to your case, Ms. Nichols, but there's a new case, which is 1980. Let me look at that one. The previous case got dismissed. Oops. There was a case in February. Must have paid.
I did.
And then there was the one in August, maybe that was paid. And the new one is set for scheduled first notice. It's not scheduled till Halloween. The new case is set for October 31st. So you don't have an obligation to be here today. It's set for October 31 at 9:20. That's a long ways away.
Right.
All right, you're good to go.
Okay, so does that mean, can I ask you a question?
Yes?
So I just literally, they just set it out until October 31st, so I just have that amount of time to get what I owe paid, or what? I mean.
Yes.
Okay.
Yes.
All
I
right.
stay in contact with the management.
Okay,
All right, thank you.
thank you.
Excuse me once again. Oh, boy. All right. Miss Wing and Miss Hall are back. Miss Bennett, we can return to your case.
Thank you.
Miss Hall, I'll go back to the same question that I asked. I'm not sure what I'm dealing with here.
Your Honor, it looks like it was filed as a non-payment of rent, but it is supposed to be a termination of tenancy for cause, and there are issues inside of the home, and of course, that's not for the park to say anything, except for the fact that there is an abundance of insect infestations that are spreading to other neighboring units. There's also many reports of Miss Bennett being disruptive, drunk in public in the area. She said the police called on her. As far as I'm aware, when I was speaking with the manager, she's spoken with Miss Bennett numerous times, and Miss Bennett has agreed to vacate and leave the home there. She hasn't done so now, but I think she's trying to get into subsidized housing and doesn't want a judgment of eviction on her record. So they had discussed doing a conditional dismissal. I don't know if she's still amenable to that, but that's where we're at.
All right, so it's her trailer. She's discussing simply leaving the lot and relinquishing the trailer to the ownership of the park.
If that is what she wants to do, I mean, I think just would like for her to vacate.
And Judge, I'm certainly happy to consult with Ms. Bennett before she waives
Yeah.
any rights on the record here.
Well, this thing is not in good shape. My inclination is to put you all in a breakout room. Miss Bennett, have you discussed moving?
Yes, I have. And I'm trying to get subsidized housing. That's why I don't want this against me. But I do not have bugs and everything in here.
All right, if this goes on your
I got
record, all right, if it goes on your record, it could prohibit you from getting into subsidized housing. They don't have any business on what's going on inside your trailer. This is not an apartment. This is a trailer that you own, and you rent the lot from them. Now, if the outside of the trailer is all junkified with diaper bags and junk, they could pursue that. But this is in a weird posture. In fact, it's in a non-starting posture. But if they go through with this and you do get evicted, it would make you ineligible to get into subsidized housing. So I'm going to put all of you in a breakout room. I'm going to be here. I've got some other things to address. And I'm going to add Karen Bennett and legal aid Meg Bauer. And you can all hit the button that says join and see what is to be discussed. I'll be here when you get back.
Judge, since the Everling English case is coming up, I presented that case through our case review process yesterday afternoon, and my firm is interested in filing an appearance in that case. Opposing counsel is not here, so I don't think.
Mr. Popovich, maybe someone's here. Is anybody here on Enchanted Glen besides the manager?
Yeah, I am. Abby Everling.
All right, and who are you?
Co-head of household.
She's the defendant, Judge.
All right. Oh yeah, Everling and English, and Evan English is here, but there's nobody here on behalf of.
Yeah, I'm here as well.
Okay.
Because I was going to be in the breakout room, I wanted to let you know, Judge, that legal aid is interested in
All right,
investigating
I
that
won't do
case.
anything without you, but the problem is you could be in the breakout room for a while on this other case. Well,
That's-
everybody join the breakout. Miss Bennett's already in there because she's by phone only. Mr. English and Miss Everling, you stick with me for a minute.
And I realize this is just a first hearing, Judge, so I don't need to be present.
I'm gonna advise them of their rights and then I'll wait for you. Okay.
Thank you.
Mr. English, would you land somewhere? It makes me dizzy when people are walking around.
Sorry about that.
All right, could you guys join the breakout? Ms. Hull and Ms. Wing?
I didn't get the option.
It should be there.
I don't see it.
At the
You
bottom,
can't join.
it says join breakout room, and it'll take you to breakout room 1 if that's where we're supposed to go.
Yes, that's where I put everybody.
Okay.
I don't see it.
So go to the bottom, you know where it says audio, video, participants? Do you see that? At the bottom, you have to move your mouse around.
Let me
first.
return to the main session and see if then I can put you back in the,
What the heck?
Karen Bennett, I'm gonna put
Hello?
you back in the breakout room, Miss Bennett. Let me see, Miss Wing. You should be in it.
Yeah, I don't think she is understanding. If you have to move your mouse around, Melissa, and it'll, at the bottom, it will come up. There's a bunch of options like audio, where you mute yourself. All the way to the right says join breakout room.
Nothing says join breakout room. I have participants, reaction, share screen, more. Oh, okay. I just had to go in there.
All right.
All right.
All right, Miss Everling and Mr. English, while we're waiting for a lawyer to come, let me advise you of your rights as tenants in a landlord-tenant proceeding. This is filed as a demand for non-payment of rent. You have a right to have an attorney. If you cannot afford an attorney, legal aid attorney may be available to help you. And Ms. Bauer from Legal Aid said they are going to accept this case. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. If you do wish to have a jury trial, you must tell me at this first court appearance or file a written demand within 5 days and pay the $50 jury demand fee unless the judge waives it for your inability to pay. If your landlord has asked you to be evicted because of non-payment of rent in a residential property, and that's what this is, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, or federal help for homeless veterans. And we should have sent you that information with the original packet. If both parties are interested, we can refer the matter for a potential settlement through mediation. If both parties are interested, the court can help set that up, but it takes both parties. Or you may be able to reach an agreement with the landlord that means a conditional order of dismissal would be entered. It means the case would be dismissed without prejudice, and that would resolve the matter. And normally the attorney would prepare that. All right, the manager from Enchanted Pine is here. Mr. Popovich, who has filed an appearance, is not here yet. And let's see what we got. All right, now I also have 2 civil matters which are supposed to start at 10. Omni Credit Union versus Angela Randazzo and JP Morgan Chase versus Beth Klein. I don't have anybody on either of those cases. I have Holly Jefferson. Mitch Jefferson, which case are you here on? Your microphone is on mute.
Can you hear me now?
Yes, which case are you here on?
It's supposed to be with Omni Bank. My son was served with the paperwork of something that goes back years ago. It was over repoing a car, which they got. They raised the payment so high, we just couldn't afford it.
Yes, all right, well, I've got Omni Credit Union versus Angela Randazzo.
Yeah, well, that ain't us. It was James Binkley supposed to be.
James Binkley?
Yeah, my son.
Yes, okay. That's you, Mr. Binkley?
Yes.
All right, let's see where that is. Do you have your subpoena there with you?
He never got it. We just, he came to where we live.
All right, stop.
Okay.
You're not a lawyer and he's a big boy and he has to speak for himself. You can't represent him. But let me figure out what the deal is here. Do you have some sort of notice for this morning?
No, sir.
All right, well, let's see what I can find out. Omni Credit Union versus James Binkley. Defendant called. Subpoena filed 8/1 will appear. Set for July 10th, adjourned, pending further action. So it was an asset discovery on 9/12 for James Binkley only. Plaintiff attorney called and requested an adjournment. So the matter has been adjourned. We don't know yet what date. Apparently Ms. Salisbury was not available. So you'll get a new notice for a new date, Mr. Binkley, but it won't be today. If you have any questions, you can call the law firm, the Salisbury firm. But your case for today is adjourned because the attorney was not available. It'll be rescheduled. All right. Good luck. All right. Then Mr. Popovich, and no one's here on behalf of Enchanted Glen. They're about.
He's in the waiting room, Your Honor.
No, is he?
That's what
I
he
got
just told
3
me.
people. All right, there he is. Stacy Salisbury here. Miss Salisbury.
Good morning, Your Honor.
Good morning. I just had James Binkley here, and our file said it was adjourned, so I let him go. I didn't realize at that time you were in the waiting room. Could have probably actually accomplished something.
Yes. I don't know if he probably didn't provide a good phone number.
I let him go, and 1 second later, I realized you were under the pin. I couldn't see who was in the waiting. I was waiting for Mr. Popovich, and he'd been here the whole time. So his mother, we may have a number. So Michelle, if you got that lady had called several times on that Bennett case, or on that Binkley case. If you got a number, would you share it with me? All right. In the meantime, we've been stalled out on Enchanted Glen. Miss Salisbury, Miss Randazzo is not here, so we'll make a record on that. But let me take up this matter. Mr. Popovits, I've advised the defendants of their rights. Megan Bauer advised that legal aid is going to file an appearance on their behalf. She's in a breakout room with other defendants right now. Let's see what the situation is here. Your manager is here. Could you state your name for the record, please?
Your Honor, Gary. Thank you, Your Honor. Gary Popovits appearing on behalf of Enchanted Glen. And then, sorry, go ahead, Kim.
It's Kim Shaw.
Your Honor, also, thank you so much for the courtesies today. And to restate, because I'm usually, I like to make sure I hold myself accountable for any oversteps. And you did characterize that I've been here the whole time a minute ago. I actually did log on about 10 minutes late. I had this down. I thought it was a 10 o'clock start, not a 9:50. So I apologize for any confusion and inconvenience I created within your docket. Sorry.
Well, we're all here, so let's see what we got. What's the current arrearage?
Kim, do you have that handy? I'm pulling it up, but if you had it.
$2,117.
Through September?
Yes.
How much is rent or how much is late fees?
$737 is their rent and their late fee is $10 late fee.
How many late fees are included in that $2,117 figure, Kim?
There is 1, 2, 3. They have not added September's on. They usually don't do it until like around the 15th.
So that's $30 in late fees. The rest of it's rent.
Yes.
All right. And how much are the court costs?
Filing fee is $130, Your Honor. Court mailing fee under the statute is $26. Service fees are $110.80. And a statutory attorney fee of $75 would also be requested.
All right, let's add that up. 130 plus 26 plus 110.80 plus 75 is $341.80. If we add that to the amount of rent requested, 2117, we get $2,458.80. All right, Ms. Bauer is in the breakout room with another case, so we're gonna just everybody stay put where you are. I'm gonna take care of the esteemed Stacy Salisbury, and it was just right. As soon as I clicked him off, I clicked you in and had instant regret. I went into the file and it said counsel unavailable or something, and his mother was speaking on his behalf, and so I just said, I don't know the new date. Well, we could have accomplished something this morning, but let's talk about something where we aren't accomplishing much, which is Omni Credit Union versus Angela Randazzo. This is a fairly substantial debt. It's north of about $13,000. Attorney Stacy Salisbury is here on behalf of the plaintiff. The defendant is not. We had a previous hearing in July, and we set this motion for show cause today. Defendant failed to appear pursuant to a duly served subpoena and failed to appear for the show cause. Ms. Salisbury, are you going to request a bench warrant?
Yes, Your Honor.
I'm going to do a bench warrant for contempt. $1,000 cash only. May be applied to the debt. It takes a lot to get a bench warrant in a civil case, but contempt is failing to appear pursuant to a duly served subpoena, and we do boot, belt and suspenders, and we do a second hearing, which is a cost to the plaintiff for a show cause. She didn't show up for that either. So the only thing left is to issue a warrant for her arrest. Ms. Salisbury, you're good at these, and you can submit the bench warrant. Sergeant Morse will execute it. She can either post the $1,000 bond and we'll set a hearing. If she does not post the bond, we'll contact you on short notice and attempt to do the discovery.
I will get that submitted, Your Honor. Thank you.
All right, thank you. And no one's gotten back to me yet. Michelle, did you have a number for Mr. Binkley? Or his mother? Or
And
Elaine? Sorry, go ahead.
I do see, because we had actually just recently, so which is why it was getting adjourned, on the affidavit of attempts, it does look like the officer had talked at some point to his mom, so she might be the best bet to get in touch with him.
All right, well, he was there with her. But anyway, I let him go, and no one's gotten back to me with any information.
Okay, I'll try to get it resolved before the next date, Your Honor.
All right,
Thank you.
thank you. All right, we're still struggling with two cases. We need Meg Bauer. And I do have another 10 o'clock case, JP Morgan Chase Bank versus Beth Klein. It is a motion for summary disposition. There's an attorney for the plaintiff, Stinger and Stinger, and there's an attorney for the defendant, Jennifer Payon. Neither party has appeared, which makes me think perhaps this matter's been resolved. Yes, his mother had called the court a couple of times.
Yeah, we don't have one.
All right.
In the system.
I let her go. All right, you can have those.
She's getting the mail.
All right.
But she didn't answer.
All right, we're waiting for Sweet Lake and Bennett, and we're waiting to complete Enchanted Glen. But we can't seem to get all the players in the same place at the same time. I'm gonna close the breakout room because I don't have the luxury of waiting.
There.
All right. Ms. Bauer, I need you back, and I need to move these cases. Regarding Sweet Lake versus Bennett, the case is in an odd, untenable posture. Defendant would like to move. Perhaps it could be subject to a conditional order of dismissal, but we're going to need to continue this matter. Ms. Hall, what's your suggestion?
Your Honor, I spoke with Ms. Bauer, Attorney Bauer, in the breakout room, and we were agreeing to a 1-week adjournment so we can look into different things on both sides.
All right, next week is busy. Let's see where we could put this. Let's set this for, let's just pushing it, 9:45, September 19th. Will that work for you, Ms. Hall?
Yes.
Oh, I think Meg will be here anyway. All right, we'll adjourn this, see if we can get somewhere. In the meantime, Ms. Bennett, my suggestion was you continue to look for a place to move to. If you do have an apartment that's ready to accept you, perhaps that would help resolve this case. But right now I'm not sure what they're asking. At one juncture, they asked for a non-payment of rent, but the rent was 0. Then they filed the hazardous danger to the community. And then it's also not clear whether there is lot and trailer or just lot. So there's a lot of unknown here. But it would certainly be aided if you could find a place to move to. Maybe the whole thing could be dismissed. Anyway, we'll address it further next Friday morning by Zoom at 9:45.
Thank you, Your
All right.
Honor.
Okay, thank
Have
you.
a good day.
Thanks,
All right,
Dave.
thank you. All right, now Meg, we have gone as far as we can go on Enchanted Glen versus English and Everly. They're here, although I think I may have lost Mr. English.
His phone died. He's caught up in another court hearing that was supposed to end 2 hours ago. So I will be here and hopefully he'll join soon.
He's got another court hearing?
It was at 8:30 and it's been pushed back quite a bit. But he should be out soon.
Mr. Popovich indicated that rent is $2,117. That includes 3 $10 late fees. Court costs are $341.80, and the arrearage through September is $2,458.80. Ms. Bauer indicated that this was the type of case legal aid was going to file an appearance on. It seems pretty straightforward, Meg. What's the issue here?
The primary issue, although there's a couple others that may not directly bear on this case, is the timeline for recertification and changes of income. This seems to be, Enchanted Glen is a rural development funded property. It's under Section 515. Or it's also a tax credit property. This property has some units that benefit from rental assistance and some units that don't. It was unclear. This unit does benefit from rental assistance, which means there's additional assistance on top of the Section 515 funding that helps supplement the rental rate. There are rules under USDA about that program. For the timing of recertification, the property is required to complete a recertification within 30 days of being notified of a change of income that meets the threshold. And in this case, Ms. Everling and Mr. English reported a decrease in income in June, and that recertification has still yet to be completed. Now, it seems there's a secondary hang-up on completing that income related to occupancy in the unit. And as I pulled those strings, it became clear there was some family-based discrimination happening at this property. Now, I'm not planning to necessarily raise and plead that in this case, but if the rental rate or the rental assistance, because this is slightly different than typical HUD Section 8 housing, if the rental assistance rate was supposed to be adjusted based on the decrease in income, then the amount being claimed for redemption would be lower, if anything. So there's a lot of documents in this kind of case, or, in subsidized housing. I know I just went through a very fast litany of Section 515, but the skinny of it is their rent should have been reduced, or it appears to us from the facts that their rent should have been reduced back in June, and it wasn't. And I would certainly reach out to my colleague on the other side to try to discuss this and reach resolution.
right.
He doesn't have the benefit of knowing that that we decided yesterday to appear. So,
All right. Well, it isn't something that can't be resolved. If we can come up with a number, they can tell how much that they were requested to pay or move. Mr. Popovich, I'm thinking maybe we might want to bump this to a date other than next Friday. Let's take a look. Next Friday is very busy. And then I've got a ugly case, 326. We could put it, let's look at the 22nd. That's not good. I guess I could put it at 2 o'clock on Monday, September 22nd, or 10:30 on Friday, the 26th.
Either of those dates and times work for me, Your Honor.
Let's go to Monday, September.
Real quick,
Yes.
Your Honor, I'm supposed to start my job on the 22nd. It's for the hospital, and I have an orientation day from Monday the 22nd till Thursday. So I wasn't sure if maybe we could do a Friday instead, so it doesn't interfere, because if I am not able to attend that Monday, they'll have to push my start date out another 2 weeks.
And that does
All right, well, let's
conform with
go
the information I have, Judge.
9/26. What's that, Meg?
I was just substantiating Miss Everling's statement that's truthful.
We'll go to, let me look at the 26th.
I think you said 10:30. That works.
10:30. All right, Friday, September 26th at 10:30. Often, a lot of the hard work in these cases is done behind the scenes. Ms. Shaw, they claim that they gave you a notice of a reduction in income in June, and there was no recalculation. That's something you guys can discuss, and Mr. Popovich and Ms. Bauer will discuss it. And see where we are. This isn't that hard. We just need to figure out how much they owe. And now, if we dink around too much, we're going to be into October. And then another month's rent is going to be due. But we'll cross that bridge when we get to it. That is, for now, we'll revisit this on September 26th at 10:30. Mr. Popovich, anything else to add?
No, Your Honor. Thank you.
All right, thank you all.
Take
You're
care.
good to go.
Thank you.
Thank you,
Thank
Judge.
All right, that finishes the primary portion of our morning. I have an ugly damage hearing at 11. But I'm gonna.
Judge, I have a question for you about that damage hearing.
Yes.
At the previous hearing, you had instructed the plaintiff to file amended request for his claim outlining what he was, the basis for what he was claiming. We were waiting to get that, and I haven't seen that come through. As far as I'm aware, the tenant or the defendant hasn't received that.
He did not. He filed a bunch of pictures, but as you saw, you know, $4,800 of other. So you're certainly welcome to rejoin us at 11.
That is my
all right,
intention, yeah.
But no, he filed a packet with a bunch of pictures in it. Let me see if I can forward that to you.
Okay. Thank you, Judge. I know I owe Elaine a lot of paperwork after this morning.
Let me see if I can send this to. This is what we got. I got it yesterday afternoon, about 4 o'clock.
Okay. Thank you, Judge.
All right, thanks.
See you soon.
All right. All right, we're going to stop the live stream. I'm going to go sneeze a few times and be back.
A final pretrial conference is typically set about 10 days prior to the scheduled trial date. Right? There's typically about 5 or 6 cases that come before me on that day. In your file, that final pretrial conference is November 14th. Now, Ms. Moss, I can leave it set for that day, or I can have it set for a plea earlier. What would you like me to do?
Your Honor, really it comes down to this, the no contact that's currently in place that we're hoping to get lifted sooner rather than later. So I guess at this juncture, I would ask for a sooner plea date, just so, you know, I'd like to address bond today, but that I just have another opportunity to address it sooner than the 14th of November, please.
All right. Well, Mr. Kulstra, as long as the prosecutor doesn't have any objection, we're going to set it for a date sometime in October. All right. I am not available at least until the first week of October. All right. So you'll get a notice. Make sure you stay in contact with Ms. Moss or Mr. Williams, and they'll tell you when to be here for a plea. All right. Now, Ms. Moss, says she wants to make a motion regarding bond. Ma'am, the floor is yours.
Thank you, Your Honor. Your Honor, I'm just asking the court to lift the current no contact order to allow Mr. Kulstra to go back to his residence and reside with Jennifer Kulstra and his 2 minor children. Your Honor, CPS is involved. There's a safety plan in place. We have brought this before Mr. Denhouten. He is unwilling to stipulate, but I would just like to make a request in front of the court. His family wants him to come home. There's considerable hardship without him in the home. Right now, they're just available to speak on the telephone, just strictly about the children. I know it's Miss Kulstra's desire to have him back in the home. If you'd like to take testimony from her this morning, I think it'd be helpful to have her be heard. Like I said, CPS's involvement, safety plan, all of those are already in place.
Thank you. Miss, you're Miss Kulstra?
Yes.
Please raise your right hand.
Mm-hmm.
It's okay. Do you swear or affirm the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth, ma'am?
Yes, I do.
And again, would you please state for me your first and your last name?
Jennifer Kulstra.
Miss Kulstra, are you currently married to Jay Allen?
Yes, I am.
And how long have you been married to Mr. Kulstra?
The 20th was 14 years. We've
Okay.
been together completely for 19.
All right. And there are children that you have?
Yes,
How many children do you have with Mr. Coolstra?
I have 2,
How old are they?
10 and 6.
Are there any other children that live at the residence? Like, in
No.
other words, they came from a previous marriage or relationship?
I have 2 other ones that he raised from 1 and 2. They are now 20 and 21
All
and
right,
not living in the home.
okay. Now, Ms. Coolstra, these allegations, when I look at them, now, first of all,
Mhm.
I don't know anything besides the allegations. I haven't even dealt with this case yet.
Yeah.
But I do know what they say. I don't know what the scene was like, but apparently it was quite concerning.
Yeah.
Firearms, things like that.
Yeah.
And Mr. Denham, you normally do a guideline range.
We did, with respect to the, I did
Offer.
on the offer form, I did the guideline form on the offer. As charged, obviously the guidelines would be much higher.
Yeah, but just tell me what they were right now.
Uh,
Yeah, I'm sorry, what are they based upon the offer?
just looking for the form, Your Honor, I did do the guidelines. Guideline range would be 0 to 9 months.
All right. And was that, give me the count, what offense would it be? That just helps me figure out what the
Yes, Your
class
Honor.
would be and gives me an
Understood.
idea. Go
Sure.
ahead.
Yes, the proposed plea agreement would be to count 2 felonious assault. That would be with respect to Ms. Coolstra, and count, I have that reversed. I'm sorry, count 2 felonious assault. That would have to do with Sky, the child, and count 9 would be domestic violence against Ms. Coolstra.
All right. So there definitely would be several, arguably, at least based upon the facts. I'm sorry, not based upon the facts, but based upon the charges. There'd be a lot of scoring for offense variable 12, so forth like that. But just kind of gives me an idea if there was a conviction at trial, what it would be like. All right, Ms. Coolstra, why don't you tell me, if you could, what's going on? Because Ms. Maas has said that there is a safety plan in place.
Yes.
Tell me about that. I don't know what that means.
So we are in open case with CPS. Me and the CPS worker me and her have done multiple safety plans. When she first came out, we did one which was longer than what she had submitted. And then there was one that she had did with Jay and Maya here.
Okay.
The one with me, you know, if Jay was to drink, whatever, get irritated, me and the kids were to leave and not come back. And then if he was to follow me, I was to call the cops.
Are there any firearms inside the
There
residence?
is no more firearms in my home, Your Honor.
Okay.
They have all been removed.
And has that been confirmed by Child Protective Services? Do you know?
They were in the home after they were removed. Yes, they were.
All right. And Mr. Denon, were there recorded interviews of Ms. Colstra that were a part of this investigation?
Yes, sir.
And I don't see a prelim transcript. Was that waived?
That was waived. So,
Yep, go ahead.
Mayor, is it appropriate time?
Yeah.
Your Honor, so this case has been moving quite quickly. This is not an old incident. This is July 26th. I did previously agree to stipulate to allow for contact with respect to your oral contact for picking up the kids and what have you. There is a brand new CPS worker in the case that has very limited time on the case. The current CPS plan essentially says that if the defendant becomes aggressive or assaultive, to call 911 and leave the situation. There's just, my concern is there hasn't been enough yet time in place to have services to talk to the other child. This was a case where the allegation is that the defendant made threatening statements and then shot an AR-15 type style gun, not in the direction of the victims, but after making that statement. And so there was some serious concerns. He left the residence and was fleeing. So people do have some concerns at this point regarding the safety of the victims, just because of how fast things are proceeding, and that we don't believe that CPS has had enough time. I'm not opposed to revisiting this at a later date. We are just opposing the request to eliminate it at this juncture.
There's one, and I'm gonna ask each one of the council here in just a moment, Ms. Moss, 1 second. And I'm gonna allow each one of you the opportunity to ask questions of Ms. Colstrip. So don't worry, I'm not gonna go away. Mr. Denon, understanding that I'm not here today to make a finding of fact as to what did or did not occur. You did make a statement, so, and I am pursuant to Court Rule 6.106, allowed to consider the likelihood of conviction and so forth, which requires me to take a little bit of a look at the allegation. You said that there was a discharge of a firearm. What are the allegations as to how that occurred? I know you said it wasn't toward anybody, but what was it? I mean, was he out 100 yards away from the house?
So I'll try to be as brief as I can.
Yeah, that's okay.
So the allegations is that there was an argument that the defendant was concerned the fact that he had not had his gun rights reinstated because he has a prior conviction. And the defendant was upset at Ms. Coolstraw for that reason. I'm not exactly sure why, but was mad at his wife for that reason. In any event, the allegation is that perhaps not at the moment that the gun was shot, but there had been an argument because he was upset about not having his gun rights back, that he had made a statement to the effect that he was going to kill Ms. Coolstraw, and the gun was shot from the dining room area outside of a slider, pointed outside, but from within the home, outside. So it was not in the direction of it. It was, but statements were made, and the defendant's wife and the child were within a few feet of when the gun was fired.
Thank you. Now, Ms. Moss, thank you very much. I could see out of the corner of my eye wanting to talk. Like I said, I'd let you speak. I'm sorry, you can either respond to what Mr. Denham said, or you can ask questions of Ms. Colstrip, whichever you choose. You may begin.
Thank you, Your Honor. Obviously, Ms. Coolstraw was there, so I'd like to question Ms. Coolstraw. Ms. Coolstraw, are you in fear of Mr. Coolstraw at this time?
No.
And
neither
is
are
it
his kids.
I'm sorry, and then you're speaking on behalf of the children, is that correct? Are his children, the two minor children that you two share that reside with you, are they in fear of Mr. Coolstraw?
No, they are not.
And Ms. Coolstraw, have you undergone considerable hardship without Mr. Coolstraw in the home?
Yes, I have.
And have your children also suffered without their father in the home?
Yes.
And is it your and despite the allegations and the incident that occurred, is it your desire? You already stated that you are not in fear of Mr. Coolstraw. Is it your desire for Mr. Coolstraw to be back in the home?
Yes.
And in terms of your involvement with Child Protective Services, do you intend on continuing your contact with CPS?
Yes, I do.
Okay, and you're going to do anything that they suggest that's needed in terms of, okay. And furthermore, you said you've met with CPS how many times at this point?
I've met her twice, and then I have not met the ongoing worker, but the one that is still on my case is going to be with the ongoing worker when she shows up on Tuesday.
Okay, and they've already conducted a home visit. Is that accurate?
Yes.
Okay.
Yes, there was 2 home visits.
Okay, so you've had 2 home visits, and then you're scheduled for one this coming Tuesday.
Yes.
And your children have also met with the Child Protective Services worker?
Yes.
And they've expressed their desires to her as well?
Yes.
Okay. And finally, Ms. Coolstraw, you understand, you recited the terms of the safety plan quite well. So if there were to be any sort of aggression, drinking, anything, what is it that you would do?
Me and the kids would leave and not come back.
And would you have any concern doing that?
No.
You would do that, is that accurate?
would do that.
Okay,
I would
thank
leave
you.
and not come back.
Thank you. I don't have any further questions of the witness.
All right, before I let you make any argument or statement, Mr. Denham.
Just one additional point. One of the difficulties is that I don't have any clear visibility. I understand that Ms. Coolstra is representing in terms of what the feelings are of the juvenile SK. I have not had an opportunity, and I don't believe that CPS has had an opportunity to discuss the lifting of the no contact with her. And that was one of the concerns regarding agreeing to this at this point, Your Honor.
Do you have any questions for Ms. Coolstra?
I did not.
Thank you. All right, so I've heard testimony from Ms. Coolstra. Ma'am, you may go take a seat. I've heard argument from Mr. Denham. Does he have any prior acts of domestic violence that have resulted in a conviction in his past?
Well, there's a 2005 attempted aggravated assault and a 2012 attempted CSE third.
Thank you. All right, Ms. Moss. I'm sorry, Mr. Coolstra. I just realized I haven't been talking loudly enough. Hey, what? Sorry. I don't mean to laugh. That's not funny. Well, it's a bit funny. I was apologizing because I forgot that I wasn't speaking up loudly enough for you. All right, Ms. Moss, now we're down to your argument. Thank you.
Thank you, Your Honor. Your Honor, you heard testimony from Ms. Coolstra. It is her desire to have Mr. Coolstra back in the home. Child Protective Services is involved. They've been to the home. All firearms have been removed. I understand that Mr. Denhousen stated that he hasn't had confirmation of CPS's conversation with the minor child SK, but per the testimony of Ms. Coolstra this morning, there has been, this afternoon, whatever time it is at this point, there has been conversations between CPS and the minor child, and she has indicated she would like her father back in the home. They have contacted Mr. Williams' office numerous times asking if a stipulation had been signed or if there's been any agreement to lift the no contact order. I know they've been in contact with the prosecutor's office as well. Clearly, it is the desire for them to have Mr. Coolstra back in the home. We have a safety plan in place. She testified exactly what she would do if there were any sort of aggression, drinking, anything else that, you know, would potentially put them in the same situation that they're here for now. Your Honor, for those reasons, and yes, I understand that Mr. Coolstra has some criminal history. It is at this point 10 years old, I believe, is the newest, or perhaps even older than that. And again, Ms. Coolstra testified they've been together 14 years married, 19 years together. It's my understanding that neither of those allegations were where Ms. Coolstra was the alleged victim. So for those reasons, Your Honor, I'm not sure what else would need to be seen other than simply time, if that's what Mr. Denhousen is asking. And I guess just the hardship upon the family at this juncture is just, it's clear based on Ms. Coolstra's behavior and testimony.
All right, thank you. I'm going to make some findings and make some statements. And what I do, some of them tend to come off, they can come across rude and confrontational. That's not my objective. So the first thing I was going to say is something about what Ms. Moss said at the end. Might there be more that I need to know? Yes, that might be helpful. For instance, and I don't know if I've ever seen this Moss before. I apologize if I have.
No, it's okay.
When it comes to sentencing, I always want to see how a person has behaved in the past. When a sentence occurs, I get a pre-sentence investigation report. And it tells me prior criminal history, how did they perform on bond in the past? How did they perform on probation in the past? What kind of physical or mental health issues has that person dealt with? What kind of treatment program they have? Now, those things are important even here for bond, because I can always make it a term or condition of bond that a person goes to a rehab, a community mental health, something like that. That's just an example. And today, I don't have that. And I'm not pointing the finger at Ms. Moss because this is coming up very quickly. Next, I'm not Child Protective Services. Child Protective Services has their own rules and authorities that I have. I'm sorry. They have, and the things that they can't do, I can. Now, my objective here is also different than theirs. Yes, as a judge, I want to see families back together. I want to see them moving forward. But at a bond, a bond request, especially prior to a plea or a conviction, I'm concerned with the person making it back to court and the trial being able to go. Right? Now, so when I say that, somebody might say, oh my gosh, that judge won't adjust somebody's bond unless they pled guilty. He's trying to force them to. No, because I'm no longer worried about making sure the person's there, making sure that everybody gets there safely for the testimony, for the trial date. Okay? So I look at it differently when I have actually a conviction. And I've got some admission on the record. Also, and I have been, prior to taking the bench a few years ago, a prosecutor and a defense attorney. By the way, 2/3 of my career was as a defense attorney. So I've dealt with a lot of domestic violence or physical assaults or sexual assaults. And in my experience, and I'm not saying this about Miss Coolstra because I don't think I've ever met her before. If I have, ma'am, I apologize. Which, by the way, is normally a good thing when people have never met me for a whole lot of reasons. But I have to be concerned to make sure that she's making free choices. Now, I have no reason right now to think that Miss Coolstra is cowering from you, but I have to make sure that she's not a victim of what we call the power control wheel. Or not we, I mean, counselors do. Victims of domestic violence tend to always come before the judges, and when I was a prosecutor, and tell me, you're ruining my life by keeping my husband away. And then my response would be, I'm sorry you feel that. My job is X. So I'm going to deny the bond modification today. However, also with some of those things that I just stated, I have absolutely no doubt Ms. Moss was paying attention and might come to me with some of that other information. Or if there is an agreement and you wish to enter a plea, even though I will be out of the office beginning next Tuesday at noon, if she wants, I can always squeeze in a plea, or while I am gone, there will be a judge to cover. However, that judge will not take a plea unless the defendant waives the right to allow me to do the sentencing. Let me explain. When someone enters a plea of guilty in front of a judge, they have the right to have that same judge do the sentencing. I suspect that while I am out, my substitute will not accept a plea unless the defendant waives the right to have and agree to let me be the one who sentences them. Again, Ms. Moss, I'm really talking to you. All right. So that's what I'm concerned about. These allegations are real serious. And here's what I want you really to understand. Mr. Coolstra, I don't think I've ever met you. Have I met you before?
One time.
All right. Well, let's assume it was under great circumstances. I don't remember it, but that's okay.
It was.
All right, good. I don't know anything about you. You know, for instance, we do guilty pleas where some are called Cobb's agreements where I take and I agree to the sentencing right away. I don't do those because I don't know anything about the person seated there. Now, a pre-sentence investigation report helps me learn all that. That's why I don't do Cobb's agreements. And in a PSI, which I know Ms. Moss knows what's in them, That makes me feel a lot more cushy and safe and warm inside when I give this sentence. So I'm not gonna, I deny the motion as it is today. Ms. Moss can raise it. Ms. Moss, I leave on Tuesday. And I've told my staff to block out everything after 12. I could make an exception. By the way, I really don't have to leave town until 3. Mr. Coolster, I've been married for a long time. I know that if I want to leave at 3, I tell my wife I want to leave at noon. All right. So if you want to enter a plea on Tuesday and you want to take it at 1 o'clock, you can tell my staff that I'll take it at 1 o'clock and I can do it over in Wexford County. Okay.
Okay.
Hopefully I've done a lot of, yes, I've done a lot of talking. Mr. Denhart, you can always appear via Zoom.
Yes,
I don't care. But Ms. Moss, that allows you to be physically present with your client to make sure you can communicate effectively with him. Now, if there is, and I'm assuming that if we take a plea, Ms. Moss is going to, man, I feel like I'm yelling. Ms. Moss is going to want to motion again. Ms. Kustra, you may want to be there. Okay. Anything else, Mr. Dunlop?
No, Your Honor.
Anything else, Ms. Moss?
No, Your Honor, thank you.
Thank you. And again, I apologize for yelling. I'm trying to make sure Mr. Kustra can hear me. All right, thank you. We are adjourned.
All right.
Well, that was complex. All right. Ms. Firavento, let's go on with Mr. People versus Gregory Zakrin, Z-A-K-R-I-N. File number is 25-3625FH. Linda, did I give you the right file?
That work is already done.
That's cool stuff. All right. Appearances.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor from South Carolina.
I realize I sound like I'm still yelling. Sorry, go ahead. Yes, ma'am.
Thank you, Honor Taylor and Anna Trevento on behalf of Mr. Zakrin, who is present and seated to my left.
We're here today for the taking of a plea. Mr. Ringstrom, the plea trial agreement, please.
The pretrial agreement would be that the defendant would enter a guilty plea to OWI 3rd as count 1, people would dismiss count 2, and Killebrew agreement of sobriety court, which we feel in all actuality, we have a response back from the sobriety court indicating that they will allow me into that program.
All right, so pleading to count 1, agreement to sobriety court, Killebrew, dismissal of count 2.
Correct, and then after 1 year, we go down to OWI 7.
Yep, got it. Ms. Fiorento?
That is correct, Your Honor. Thank you.
Thank you. All right, Mr. Zakrin, I'm told that, gosh, I'm still doing it. Mr. Zakrin, I'm told today you're going to enter a plea. Is that what you wish to do today?
Yes, Your Honor.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
So you may lower your hand. All right, Mr. Zakrin, I just need to ask you, go over a bunch of questions with you. Looking back to July 5th of this year, were you on probation, parole, or bond at that time?
No, Your Honor.
You were currently charged on a piece of paper called a felony information with 2 counts. Count 1 charges you with operating a vehicle while intoxicated per se by having a blood alcohol level of 0.08 or higher. Now, that is as a third offense. The third offense element, portion of it, makes it a felony, punishable by a minimum of $500 to a maximum of $5,000, and then either a minimum of 1 year to 5 years in prison, or in the alternative to a prison sentence, the court would could place you on probation, and then you would have a minimum of 30 days to a maximum of 1 year in jail. 40 hours to be served consecutively, 60 to 180 days of community service, cost of prosecution, mandatory vehicle immobilization of not less than a year, not more than 3 years, costs and expenses for prosecuting the case. I'm told you're going to plead guilty to that offense. Count 2 is operating a vehicle while your license is suspended, denied, or revoked. That's a misdemeanor punishable by up to 93 days and or up to $500 plus vehicle immobilization. Now, Mr. Ringstrom has got his arms braced upon his chair over there, which means he wants to stand up. Yes, sir.
Thank you, Your Honor. Although the complaint does say that 0.08 grams or more, the factual basis is going to be a combination of alcohol.
Okay. So instead of it being basically just a, what we call or per se, it's going to be a combination of an illegal or controlled substance and or alcohol together. Okay? Thank you. Now there's an agreement called the Killer Brew Agreement. That is an agreement that if at the time of sentencing I don't go along with it, I'm doing it again. If I don't go along with it at sentence, you would have the right to withdraw your plea and come back to the stage in the proceedings. Now that pretrial or that Killer Brew Agreement is that the court would place you into the sobriety court program. That program lasts for 2 years. That program is operated by the district court. If you are successful with that program after 1 year, they'll let me know that you're doing a good job. Then I will make a decision and dismiss the third, let you plead to the second, and then kick the case back down the sobriety court program for the last year. Now, if you are successful with that program, it works out well for you because you get a reduction in the charge. And right now, as I told you, the charge involves a couple mandatory confinement periods. Does that make sense? As well as vehicle immobilizations. Okay? Make sure you say yes or no. Thank you.
Yes, Your Honor.
That's okay. Thank you. All right. Now, is that how you wish to proceed?
Yes, Your Honor.
Now, by entering a plea of guilty, if I accept that plea, you'll be waiving certain rights and not have a trial. Those rights include the right to be tried by a jury, the right to be tried without a jury if you chose and the court and prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. You understand that?
Yes, Your Honor.
And I'm holding up what Mr. Bento just gave to me. It repeats everything that I said, and I see that it appears to have your signature. I'm holding it up so you can see it. At the top, it says advice of rights. Is that your signature at the bottom?
Yes, Your Honor.
Did you read through all those rights before signing?
Yes, Your Honor.
And again, do you understand that if you plead guilty and I accept that plea, you'll be forever waiving those rights as they apply to this particular case?
Yes, Your Honor.
Additionally, you'll be given up the right to claim the plea was a result of any promise, threat, or inducement not told to me today on the record, or the plea was not of your own free choice. Are you entering this plea today of your own free choice?
Yes, Your Honor.
Other than the terms of the agreement that we've gone over today? Have there been any other promises, threats, inducements to force or compel you to plead guilty that we haven't talked about?
No, Your Honor.
Now, has anybody made any promises to you as to exactly what the sentence would be from the court?
No, Your Honor.
Do you still wish to enter the plea of guilty?
Yes, Your Honor.
As to count one, operating while intoxicated is a third offense. How do you plead?
Guilty, Your Honor.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of that offense. Turning your attention to July 5th of 2025, out in Butterfield Township here in Missaukee County. Were you operating a vehicle, looks like out on M55?
Yes, Your Honor, I was.
And did you get pulled over by law enforcement?
Yes, Your Honor, I did.
And at that time, or prior to operating that vehicle, or even I guess while operating the vehicle, did you consume some alcohol and or a controlled substance?
Yes, Your Honor, I did.
All right, let's tell me about the controlled substance. What was it that you had consumed or used that was in your bloodstream?
I used marijuana and I also drank, and it affected my ability to drive or operate the moped, and I fell down.
It was on a moped?
Yes.
All right, so you actually, it impacted you enough that you had a little accident.
Yes, Your Honor, I did.
Mr. Ringstrom, what were the toxilizer results or blood draws?
3 hours after the fact, Your Honor, it was a blood draw. There was 0.077 alcohol in the system and 2.7 nanograms of THC.
All right, Mr. Zachary,
Yes, Your Honor.
is it also true that back on or about July 20th, back in 1995, you were convicted of operating while intoxicated down in the city of Dearborn here in Michigan?
Yes, Your Honor, I was.
It's also true that you were convicted of operating while impaired on November 30th, 1994 in Garden City?
Yes, Your Honor, I was.
And then again, also in Garden City on October 11th, 1992.
Yes, Your Honor.
Mr. Ringstrom, do you believe you brought out a factual basis?
I do, Your Honor.
Are you aware of any of the promises, threats, or inducements?
I am not.
Do you believe the court supplies the court rules?
I do.
Mr. Vento, do you agree with all three?
Yes, Your Honor.
Court agrees and finds that defendant's plea is made freely, knowingly, and voluntarily. Court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the offense. Therefore, the defendant is found guilty of count 1. Count 2 will be dismissed at the time of sentencing. Mr. Zachary, we still have the case set for sentencing here before I remand the case down to the sobriety court program. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentencing investigation report. That report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide while preparing that report, as well as make recommendation as to the sentence. Now, there's a reason why, there are 3 steps that involve you in the preparation of this report. Number 1, Ms. Westorp is going to give you a packet. You're going to open it, follow the instructions, complete it, and turn it back into the Department of Corrections, also known as the probation control office. Number 2, you'll have an interview with that agent. You have the right to have your counsel present during the interview. And number 3, you need to make sure you stay in contact with Ms. Firavento, as she or someone from her office will meet with you after they receive this report. And generally, it's about 10 days to 2 weeks prior to sentencing. And they'll go over it with you. Each side has the right to come back to the court and request corrections or make objections to content of the report prior to the court issuing a sentence. We want to make sure that all that information is complete and accurate before the court issues a sentence. Do you understand?
Yes, Your Honor, I do.
Now, there's a reason why I still have the PSI report done, even though you all have probably spoken to sobriety court. I think somebody said that. That's up to them as well, not to even start taking you early, but the reason why I don't do it today is because I don't know you, right? So there's this report. They look up your criminal history. I want to make sure that I want to put you into the program. Let's say, for example, you have, I'm just using this as an example, I have no reason to think it's true. I'm not trying to insult you. Let's just say, for the sake of discussion, you've got 20 prior drinking and drivings. And not everybody knows about it because they're not well documented in some other county, in some other state. Or maybe you are wanted on warrants for being a serial killer. I don't know. I know that's not true, but I'm just trying to use something that sounds as silly as I possibly could come up with. Sometimes I use the example of the jackal. You ever heard of the jackal? Allegedly an assassin. Never mind. The point is, I just want to make sure I know who you are. Okay?
Yes, Your Honor.
And then we'll put you in the program. In the meantime, I strongly encourage you to go to Catholic Human Services, go to AA, NA programs, because the objective here isn't necessarily to punish you, but it's to help you. It's about rehabilitation, and that's why we have the program. And that's why I strongly support Judge Wiggins operating the program. Now, if you are ever on the program, by the way, since I'm thinking about it, because I watched it the other day, don't be on your phone when you're doing the program. Now, in Wexford County, if they're sitting there, they're not on the phone. But when they're sitting here and they're appearing via Zoom, there's always somebody doing this on their phone thinking the judge can't see you. Don't do that. All right. Otherwise, you're not getting the benefit.
Right.
All right, great. Anything else? Oh, wait. Yes. Guilty of count 1, count 2, Smith. Yep, got it. Anything else?
No, Your Honor.
Anything else?
Just ensuring that the reduction in the charge at the 1 year mark. Thank you.
Yeah. Oh, and after 1 year, the charge will be reduced. I didn't cover that well. We'll deal with that thing. All right, your bond conditions remain in effect. Thank you very much for your patience today and resolution. Have a great weekend.
Is it Cerise Christian? And Dylan Rose.
Illustrated for the plaintiff.
Okay. Your name?
Dylan Rose.
All right. And where are we on this case?
I signed a conditional dismissal
with Barnes and Barnes and agreed to pay the amount by the 19th.
That's
Sure.
That's partly correct. We sent him a COD and before I had a chance to look at it, it didn't have the immediate writ along with the judgment language in it. We sent it back to him and he didn't sign it.
I didn't know, I didn't realize I had another.
You had another.
I signed a document. They told me everything was fine last I spoke to them.
But did you get the second document?
I didn't get the second document.
You're saying you didn't get the second one, Mr. Freeman.
Okay, well.
Well, you're gonna pay it by the 19th.
Yes.
The whole balance.
Yes.
Okay. So here's what I will do. Partially because it's more beneficial to you.
Okay.
If you get it paid by the 19th,
Mm-hmm.
then the case will remain closed.
Okay.
Dismissed.
Okay.
Don't pay it by the 19th, then I will sign a judgment with a writ date as though it had happened today. So you'd have like 3 days to get it paid.
Understood.
Okay.
Yep.
You understand what I'm doing?
I understand.
You follow that, Mr. Friedman?
Sure do.
All right. And so they'll send you a copy of the COD if it comes in.
Okay.
That's fine, but we'll do it that way. Okay.
Okay.
All right. So I'll mark this conditionally dismiss, order to follow. But if not, judgment will enter with the writ date of the 22nd. Okay.
Understood.
All right. Very good.
Thank you.
Thank you.
It's 75 and
That's
sunny.
it.
Lake, Your Honor.
All righty, sir. Take care. Have a great weekend. Arbor Woods versus Leticia Johnson. And is there somebody else? There is. Adrian Johnson. Oh, but I know why I did that. Go ahead, Ms. Smith.
Good afternoon, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
No matter, Ms. Matson, no matter what anybody said, I did not throw you under the bus. All right, I'm just letting you know. It was not me. Anyway,
Thank you, Your Honor.
The only reason I didn't mention Adrian was Adrian. Anyway, your names. Adrian.
Leticia and Leticia.
All right. Okay, where are we on this case?
Your Honor,
Go ahead, Ms. Matson.
Your Honor, I have a total balance of $2,860.68. There should be somebody over there today to take care of the remaining repairs on the ceiling and the ceiling for the
So
ceiling.
that amount that you had was
2860.68, and that includes the court costs of $242.
Got it. All right.
I put 500 on it today, actually, right before we came.
Do you see a $500 payment today or?
I do not have receipt of that today. The last one I
Okay.
have is from the 8th.
All right. And the repairs you say are going to be done today?
Yes,
The
Your
final
Honor.
on that? Okay. Is that your understanding also, folks?
Yes.
All right. Have you figured out how you're going to get the remaining part of this balance paid or?
Well, we've just been paying on this slowly. I think by the end of the month, we should have most of it about done. We still got a couple more checks before the end of the month.
Yep.
Okay, so here's what I'll do, because the repairs have to be completed and I want to check on that. I'll adjourn this out to the 19th, 2025 at 1 p.m. for another in-person hearing.
Okay.
All right, we'll check the status of the repairs. And I suggest to you that you pay as much as you possibly can. And then we can see where we go from there.
All right.
Sound good?
Sounds good.
All right. Folks, have a great weekend.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case of Arbor Woods versus Tisha Thompson.
Casey Matson for the
And
plaintiff.
Hello,
hello, what's
I'm
your name?
Tisa Thompson.
All right. And where are we on her case?
Okay, I made the $2,000 payment as agreed last Friday after I seen you. I applied to DHS. I have an appointment with them today between 1:45 and 3:45. I have an appointment with Hawk on September 17th, I believe at 10 a.m. And I mean, I can enter into a payment plan, like I return to work next week. So.
Hold on a moment.
Sorry.
Did you get the $2,000 payment? What
Yes,
is
Your Honor.
plaintiff's back? What do you have as her balance?
We have rent to retain of $3,401.19. Cost of $186 for a total of $3,587.19. So we did receive that $2,000 payment.
Got it. And your SER application is still pending at this point, because you got to meet with them today, correct?
Correct.
And I think I did get the form in to the court. Yes, I think I got the rental assistance form in. So she'd be entitled to another adjournment. Let me ask this, ma'am. How much do you think between now and next week you can pay?
Nothing.
Nothing?
Correct.
Okay, all right. So I'll adjourn this to the 19th, 2025 at 1 p.m.
Okay.
Okay, another in-person hearing. We, at that time, hopefully we'll be able to see what SER says and what Hawk says. I would just apprise you of this, and that is, if Hawk has money, and I don't know where they are, it's pretty strapped at this point, you would have to come up with about $600 to get it down to what their maximum would be.
Okay.
That makes sense to you? What I
Yes.
just- Okay, so you're facing that, you got SER and whatever, but we'll see where you are next week.
Okay.
Okay,
Okay. Thank you.
thank you.
What time am I supposed to come to next on the 19th?
1 o'clock.
Thank you.
You're welcome.
Have a great day, everybody.
You do the same. Court calls the case of Arbor Woods versus, is it Roulette? Roulette, they are not here. If you'd like to take a default, raise your right hand.
Your Honor, there is
Oh.
actually only a small balance remaining on this account. There's only $20 remaining. So we would just ask for an adjournment so we can get that balance paid.
Okay. September 19th, 2025, 1 p.m.
Thank you, Your Honor.
Thank you. Arbor Woods versus James Lester III. And Yolanda Lester.
Thank you.
Hello, state your name.
You good?
James Lester.
Yolanda Lester.
Thank you. All right. And where are we on this case at this point?
So, Your Honor, we were able to resolve the issues with the misapplied money orders. Those have been applied. At this time, the late fees have been removed and the month-to-month charges that were incorrectly applied to the ledger have also been removed. So there's just a small balance remaining. It's $8.59.
Did you say $8.59?
$58. And
Oh, 58. Okay, I thought you said $8. Okay.
That is for water and sewage. I'm sorry.
Okay.
I have a money order for it right here.
I don't doubt that. She has the money to pay it. So here's what I'm gonna do. She's You're gonna take that over to the office.
Oh, absolutely.
Ms. Lester, I don't doubt that you're gonna do everything you tell me. I just, from the last year, I just said, I don't want to make a man. That's been your life, hasn't it? Yeah, okay.
I would like to say that, you know what, we tried to rectify this with the office there, because we own this home
Yes,
since
sir.
2019. I never missed a payment. We always pay early. They keep switching property managers, so we release the property.
No, I remember you saying
Yeah,
this.
and every time they do it, something comes up.
No, I
Yeah.
got you, but
And, you know,
I'm on it.
I'm sick.
What's that?
This almost, you know, it caused rift between our marriage. I had to go to the VA hospital for 2 days because it stressed me out. You know, I'm telling them I paid them. We have receipts. They tell them that we didn't.
We passed all that. It's all done. I have a
But
question
you're still
though.
married.
Yeah.
Okay, see? So it
have-
wasn't that bad. All right.
I have a question.
Yes.
Is there any way we can guarantee that the sheriff is not gonna come knocking on my door? Because
Because
this situation
you know what?
evolved into,
I will give you the guarantee because they don't come until they have a judgment or something else and I sign an order directing the sheriff to be there. I'm not gonna sign that order because Ms. Lester, you're telling me you have the $58 change. You're
oh,
gonna
absolutely.
pay that. I believe that that's what you're gonna do. And so at that point, and the reason I'm putting it out to the 19th is that once that's paid, they're gonna submit a dismissal and the case is done. So nobody's coming knocking at your door. You guys have.
Okay, I do have one other question.
I knew you would.
When I spoke to her this morning, she mentioned something about attorney fees. Has that been waived? Because we don't feel we should be responsible for attorney fees for something that should not have. I mean, it's been a pleasure speaking to you, and meeting you, but we could have done it under different circumstances.
Okay, hold on a second. Counsel, I don't know the answer to that.
Yes, Your Honor, the rent to retain is $58.59. The court costs are $242. So there's a total of $300.59. We are working to see if we can do something about those court costs. So we were going to request an adjournment to the 19th.
Got it. Does that make sense to you? No, does it?
It'll register later.
Pardon?
It'll register.
Let me just say, here's what.
We've got to come back here on
Let me break it down for you.
Okay.
So you've got to go pay the 58.
Mm-hmm.
Because of everything, they're going to check, no guarantees at this point. They're going to go check as to whether or not what they're going to do with those attorney fees and court costs because of what had happened. Same thing that you're saying.
Right.
They don't, as I understand it, they don't have the answer for their client yet.
Okay.
Okay. You disagree with it. If their client comes back and they want that paid, then the decision becomes mine.
It becomes another issue.
Well, no, it just becomes, I make the decision.
Okay.
Yeah.
Okay.
Yeah. We didn't do anything wrong. Paid our rent early or on time.
We've been good people.
6 years.
Okay. So can we come back on
Not doubt that. You need to come back on the 19th.
On the 19th?
1 o'clock.
At 1 o'clock?
Yes, sir.
Yes, sir.
Okay.
Okay.
Will that work?
Yes, and I'm going to pay this on the way in.
Okay. Thank you very much. And Mr. Lester, I want to say
Thank you.
something to you. I wish that there had been a lot of young men in this courtroom and watched how you treated your wife. All right, because
34
you got-
years. 34 years.
Yeah, but nothing got lost because when you got up and you got the walker there, when you got up, she got up, but you made sure she went through that door first. And you just backed up, and I have to say, I appreciate seeing that. Okay?
Thank
Guys
you,
have a
Your Honor.
blessed weekend.
Thank you.
Thank you. We'll see you next.
Yes. Arbor Woods versus Angela Cater.
Hello.
Hello, Ms. Cater. All right, what is the plaintiff's claim in this case?
Your Honor, we have rent retain of $6,963.50. Cost of $186 for a total of $7,149.50.
Ms. Cater, how is this gonna be paid?
So I know I can have it at least 5,000 paid, for sure by the 30th of this month. And I had a question on the ledger. In June, I had came in to pay my June's rent, and I was told that my money order for May was missed. So somehow they found the money order, but then they were still charging me the fee for a non-sufficient fund fee. That was on the ledger as well.
How much was that fee?
It was $50, Your Honor.
Okay, well, at this point,
Right.
certainly if I had to make a decision on it, I'd figure it out, but you
Okay.
don't have the rest. It's not like you have the rest of it right now.
No, I don't. I don't have the rest of it right now, but I know for sure that I can have 5,000 paid by the 30th for sure.
Well, here's the problem, Ms. Cater. And that is that if I give them a judgment today, it would be the 22nd
Your Honor,
that you would have to have this paid by. Yes,
Your Honor, I'd just like to clarify for the record that the NSF fee was credited back to her account.
Okay. Thank you.
okay, thank you. All right,
So, Your Honor, I would have had more today, but with my mother passing away and us needing to ship her body from Texas to Birmingham, that took my funds. I can have some. I probably can have 800 next week for sure, and then I know I can, like I said, I can have 5,000 by the 30th.
all right. Well, there's not a whole lot I can do on this, and my condolences to you, and I understand that. But there's not a whole lot I can do on this. I pushed it out to this week over the objection of plaintiff, but I felt it was necessary to do that. But you've been here a number of times, Ms. Cater, and I'm not.
Your Honor, not
Go
to
ahead.
cut you off, I'm sorry. The only reason why my June rent wasn't paid is because Amani wouldn't accept it because she said my money order had came back. So that's when that issue came in. So that's the only reason why my June, and she told me that she wasn't taking off the non-sufficient fund fee. So that's why the June rent didn't get paid, Your Honor. That's the only reason that got me back in this tribago here is because when I did go in to pay my June rent, I was turned away because I didn't have the non-sufficient fund fee added in the money order at the time when I came into the rent office to pay my rent in June.
Okay, but even if that, I'm not saying that didn't happen. Let's say it happened. You don't have those funds right now. And I get you say that there's a reason why, but you don't have those funds right now.
That is correct. I have $500 right now, Your Honor, and I can. That's what I have left of those funds because I had to go into them for my mother.
Yeah. Okay. So, Ms. Cater, here's the best I'm going to do, and this is going to be over the objection of the plaintiff, but I'm going to find that there's no tribal issue after a hearing. I'm going to grant their a judgment for their total amount of $71.40, $49.50. I would then indicate that I'll extend your writ date to the 29th, a week out. So I'll give you another week on that. So now, Ms. Cater, let me ask you this.
Yes.
If you had the 5,000, you said by the end of the month, can you have the 5,000 by the 29th?
I know on the 30th for sure I can try for the 29th, but I know that the 30th will be the date, but I could try my hardest for the 29th, Your
Okay.
Honor.
Let me ask you this, Ms. Cater.
Yes, sir.
If you had it on the 30th,
Uh-huh.
then when would you pay the other 2149?
I will be able to pay half of that on the 8th and the other half on the 15th. And I can add my October rent in there as well. If that's not already included in the,
That's not included in this
okay,
balance.
yep.
All right.
I just picked up a second job for part-time. Well, right now I'm not doing anything because of what happened, but yeah. But I will be starting that second job very soon.
Your Honor, we would object to any extension beyond the statutory 10 days. I mean, Ms. Cater's always had a balance on her account.
Yeah,
Yes, you're right. But it's always been other circumstances leading up to that. It hasn't been strictly because Ms. Cater couldn't afford paying her rent. When I originally moved in, Your Honor, there was issues with my unit, which I brought up to the property manager and everyone else who disregarded them, which
Cater,
brought us to
Ms.
you
Cater.
before. Yes, sir.
Ms. Cater. I've been
got you.
involved in enough of your cases, and there has been always sort of this huge balance by the time it gets to me.
Okay.
Somehow or another.
I
Well,
got you.
first of all, I don't think running up these huge balances is the way that you should be operating. But
Not at
on
all.
the other hand, I have to say that once you get here, somehow or another, you get it paid and taken care of and you're still there. So here's what I'm going to do in this case. I'll do it over the objection of plaintiff. I would indicate that I will issue the judgment with a writ being September 30th, 2025.
Okay.
If defendant pays 5,000 on that day, then so that plaintiff doesn't have to refile again, but I'm going to include October. That defendant, then the writ date would be extended to October 15th. I think that, well, that's that Wednesday, but it's October 15th. That's the date you
Okay.
gave me.
Okay.
Where you would have to not only pay the balance, but also your October rent. So that if the balance and October rent is not paid, and I'm just gonna let you know, Ms. Cater, I'm not hearing anything else.
Okay.
If they submit the writ, I'm not gonna necessarily have a hearing on it.
Okay.
If the only issue is whether or not it was paid.
Okay.
And I mean that on the 15th, your account needs to be zeroed.
Okay.
So that you're not coming back in here with this huge balance again.
Okay.
And I understand I'm doing that over the objection of plaintiff, but I'm gonna do that in this instance.
So that,
Thank you.
Your Honor, that's
Go
the
ahead,
the remaining balance plus October's rent by October 15th, if $5,000 is paid on or before September 30th.
Correct. To trigger anything, she's got to get the 5,000 by the 30th.
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
Arbor Woods versus Lisa Thompson.
Lisa Thompson.
Oh, she's on the, got it. Okay, what does plaintiff have?
Your Honor, I have rent to retain of $3,264.44, costs of $186 for a total of $3,450.44. And we would be asking for a judgment today.
Ms. Thompson? Ms.
Yes,
Thompson,
yes.
how are you gonna get that paid?
Sir, I don't get paid until the 15th. I was literally going to give at least between $500 to $700, and then I don't get paid again to the 29th.
But ma'am, and how much were you gonna give on the 29th?
I was going to have the remainder balance.
Have you tried to work out something with the landlord, ma'am?
I've called the lawyer's office as well, and I have not received a phone call back. I left messages.
I'm gonna issue a judgment finding no tribal issue after a hearing in this matter. Ma'am, what day do you get paid?
I get paid the 15th, and then I get paid the 29th.
You get paid on Monday?
Yes, sir, I do.
I'll issue the judgment in that full amount of the 3450.44. The writ date would normally be the 22nd. I'll extend it out a week to the 29th. You need to go in and pay that money. I'm not making it part of this. I'm giving you that extra week, but ma'am, you need to work something out with your landlord. But if it's not in there, I'm signing the writ.
So do I need to go to the office or continue to call the lawyer's office?
To pay the money, you probably need to go to the
No,
office.
to work something out with the landlord.
You're gonna have to work it through their attorneys. You can also talk to the people in the office, but you've got to the
Okay.
29th to get all of this paid.
No, sir. No problem, sir.
Thank you.
Thank you. Have a great weekend.
You too. Arbor Woods versus Mary Clark. Okay, we'll wait for you.
Hello, Your Honor.
Hello, what's your name?
Mary D. Clark.
All right. And what is plaintiff's claim in this case?
Your Honor, I have rent retained of $1,141.83, costs of $186 for a total of $1,327.83.
All right. All right, Ms. Clark,
Yes.
how are you intending on getting that paid?
Well, I don't know it for one thing. I paid all my rent and my water bill. I don't understand what's happening. I really don't. I paid September already.
When did you pay September?
On the 2nd or the 3rd.
Okay.
Your Honor, I do have a
Yes, go ahead, counsel.
I do have a payment on September 3rd for $751.78.
Okay. Where does it look like this balance? I realize it could be from a number of things, but where does it seem to derive from, counsel?
It appears there were payments in September, August, July. Oh, Your Honor, it appears that NSF, there was an insufficient funds from the August payment. That combined with an accumulation of small balances over time.
Okay, do you have how do you pay?
My credit union, people
Okay,
driven.
no, I got you, but is it by
Okay.
check?
Pardon?
Is it
No,
by
it's
check?
a money order. I don't get the, what do you say? I'm a little
No,
discombobulated
it's
right
okay.
now.
You-
But I paid by money order
Gotcha.
and it's in before the 5th of every month. May, June,
Okay,
July.
okay, so somewhere you've accumulated some fees, and we can deal with that, but the big thing seems to be your August payment was
I paid it.
NSF.
I paid,
I'm not sure how that happens with the money order.
I'm not either. No problem with the rest of them.
I know.
Uh-huh.
I got you. I'm
Got
just
you?
trying to,
Okay. I don't understand.
do they, Ms. Mattson, does it show no payment or does it show a payment and then it was reversed out?
Your Honor, it
That's a-
does show a payment and then it came back as NSF. I'm not entirely sure reason that it came back. If defendant has some sort of proof that it did come out of their account.
Okay, do you? So when you go get when you go to the credit union to get your money order,
Mm-hmm.
right? And they take that right out of your account? Is that how they
Yes.
do it?
Oh, they don't take it right out of my account. No.
Okay.
I get a money order and take it into them.
No, 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 no. I'm talking about the credit union.
Oh, the
So
credit
when you
union?
go in, you say, I need a
Right.
money order,
Mhm.
and you're not coming in with money. They just take it out of your account and
That's
give you a money order,
correct.
right?
That's correct.
Okay, so when do you normally do that in the month?
Before the 5th of every month.
Okay,
Mm.
so you go to the credit union before the 5th of every month, and this is what you do.
This is when my checks
Okay.
come in. Yes.
So do you have, who's that with you?
This is my niece, Marcia
Hello, Mark.
Preston,
All right.
and she's been helping me a lot.
No, I see that. Who's the other one that's a big helper?
Great grand and great niece.
Great grand, great
Mhm.
niece. Oh, look at you. You are cute. What's your name? Hi.
Tell them your name. What's your name?
Michaela?
Montasia.
Montasia. That's beautiful.
Mhm.
you.
All right. Do you have, I see you have a stack of papers. Do you by chance have something that indicates that that came out of her account in August?
From the bank.
Yeah. I don't know if you have that or not. And if you did, that'd be great, but
No, but we could certainly get it.
right, that's, okay. So here's what I'll do. Because I'm not sure. I'll adjourn it to September 19th, 2025 at 1 o'clock. Okay, because the one thing I'm not sure about is how they get a money order. It goes in, then goes out, back out NSF,
When,
because it should have been honored.
if I may, when we went in and spoke with someone in the office, they said it was a mistake and that they would fix it and they were supposed to call her back and she never heard from.
Okay, so
And
that's an important fact. So you went in, talked to somebody in the office, they said it was a mistake. What part was a mistake?
The insufficient funds,
Got it.
first of all, and so that would be, I don't
For August
have exactly. I have a August receipt here. Yeah.
from them? Okay, it would, because you would have gone in, paid it, but they're saying that whatever your form of payment is came back. I'm not sure how that happened.
I don't understand.
And then if you're saying you went into the office, they told you that, council's probably gonna wanna check on that, because I don't know how a money order comes back NSF. I mean, I guess it could theoretically, but, so here's what I'm gonna need from you. I've adjourned it out 1 week. And I'm gonna need, and why don't we go back to, say, June? And just get your bank statement showing, so that I can see it showing that you've taken that money out each month. Okay?
Don't we have them? It's on my receipts. I don't know.
No, I know what he's asking for.
Okay,
We'll
I'm
get it.
all
We'll get
discombobulated.
it.
No, you're good. Okay, somebody's here with you. We'll get it, we'll figure it out. I just want to take a look back. You make that payment and then at the same time, I'd ask council to check if it was a money order, how it was NSF,
Yeah.
whatever it was, a mistake.
Okay,
Okay? Is
all right.
that okay? You still discombobulated?
Yeah,
Okay, me too. Don't worry about
are you? Well,
it. We can be that way together.
yeah,
All right.
thank
You
you.
take care.
You too, thank you.
Bye-bye, little one.
Say goodbye.
Bye.
Thank you for being good.
Arbor Woods versus Sarah Allison. Sarah Allison. They are not checked in, and I don't think I've had you sworn.
No.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $3,441.50. Cost of $186 for a total of $3,627.50. That will be writ to issue after September 22nd.
Okay, yes. Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested, writ to issue 10 days. Arbor Woods versus Charles Hardy.
Good afternoon, Your Honor. Andrew Campbell on behalf of the defendant, who's approaching the podium and standing to my right.
Your name, sir?
Charles Hardy.
All right. What is plaintiff? Where is the balance? According to plaintiff today.
Your Honor, there's rent to retain of $991.10. Cost of $186 for a total of $1,177.10.
Came down quite a bit. All right.
Your Honor, we would request a 1-week adjournment. My client informs me that today he made a payment of $1,000 and he can pay the remainder later this afternoon. Is that correct, sir?
Yes, Your Honor.
So you paid $1,000 today?
Yes, Your Honor.
You don't have that obviously, counsel, or do you?
I do not, Your Honor, but that would leave a very small balance remaining.
Well, hold on a second. Between the last time you were here, the 5th, you made another significant payment, apparently, right?
Yes, Your Honor.
And then you paid another $1,000.
Yes, Your Honor.
I do have a ledger, Judge, showing those payments if you'd like to see it other than the $1,000.
I'm good. All right, so I'm gonna indicate you're gonna pay the balance. So $1,000 went in, the $177.10. When are you gonna get that paid?
I can get that done today.
Oh, okay.
I'm actually just waiting on my wife to get off of work.
Okay, so what I'll do is I'll adjourn this out to the 19th, 2025, 1 PM. You probably won't need to come back, just double check and make sure. If the $1,000 to go in, you're gonna pay the other part. It'll be all paid up. They'll probably dismiss the case.
Yes.
All right. Thank you.
Thank you, Judge.
Arbor Woods versus Gwendolyn Brownlee. Thank you for holding that door. You know, I like it when gentlemen are gentlemen. Hello, ma'am.
Hi,
What's your name?
I'm Gwendolyn Brownlee. I'm a homeowner, so my home went into closure, and I'm voluntarily giving it up. And I'm 90% moved, and what the problem was last time, Triad told me to give the keys over to Arbor Woods, which was part of Sun Community, and I guess they don't know what I'm talking about, because the manager called yesterday and on Arbor Woods, and I told her I'm almost moved out. I'm 90% moved out, and I give her the keys next week. She was still telling me she didn't know anything about it. So I spoke to the lawyer with the Triad, and they said they would take care of it. They would know what to do. So I don't.
Okay. Counsel, you know anything about that?
Your Honor, I do, I am aware that she's planning on surrendering the home,
Yeah.
triad, and a part of that is handing over the keys to Arborwoods. My client is aware of her surrendering the keys. I don't know if maybe it was before the conversation,
Got it.
that she had the conversation with her, but she's aware. But since the keys have not been surrendered as of yet, we would ask for entry of the judgment today. Because there is still a balance remaining.
I know,
Yeah, no, hold on.
okay.
When are you, you're 90% out. When are you gonna be out?
Within the next few days, I mean,
No,
for sure.
you're okay. Just,
And if you give me a week, I'll be completely out. I'm 90%. I'm depending on my grandchildren to help me out. And it's, the major part is gone. It's just after being there for 7, 8 years, I have so much stuff. So, you
I
know,
hear you. Okay. There is a balance outstanding, but what I'm gonna do, you need to, so I would issue the judgment certainly next time.
mhm,
You need to surrender the keys to them by the 18th.
okay.
Okay, let you get your stuff out, tell your grandkids you're on that deadline. And if I gotta come and find them, then I'll come and find them.
Okay,
All right?
yes, thank you.
September 19th, 2025 at 1 PM.
Okay, thank you. very much.
Okay, you're welcome.
So do I still come back, even if I give them the key or,
Well, this is for possession. You're gonna surrender possession,
right?
right?
So I still come in?
You don't need to come.
Okay,
If,
all right,
all right,
because I'm definitely giving them the key.
pardon?
I'm definitely giving up.
But you gotta give the keys to them. It looks
Okay.
like all of the conversations have taken place. You're 90% out. I'm gonna give you time to get the other 10% out. Get
Okay.
it done. Give them the keys and then I don't need to see you on the 19th.
Okay, thank you.
Thank you.
Thank you, Your Honor.
Arbor Woods versus Tanisha Booker.
I'm here.
All right. Hello, Ms. Booker. All right, what is plaintiff's claim at this time?
Your Honor, rent to retain is $3,507.25. Cost of $186 for a total of $3,693.25. Your Honor, she wasn't supposed to make a payment, which we did not receive, so we would be asking for entry of a judgment today.
Right, I
She
see that.
definitely got it, and I have proof that she had it because they took a copy of it and gave me a copy. The lady told me that she wouldn't apply partial payment to the rent unless it was paid in full. I said, well, this is my judgment to give you $18.45 today, and I don't get paid again until the 19th, and I'll have the rest. She said, well, I won't apply it to your account, but make sure you let them know that you did pay it. I have a copy and a ledger copy.
Hold on,
When did you provide that payment, Your Honor?
Ms. Booker, when did you pay that? She froze.
Oh.
Great.
Close Monday.
Ms. Booker, you're gonna have to go back to where you were and stay there because I'm not getting a Wi-Fi signal from me. I can't hear you. Ms. Booker?
Yes.
All
Can you hear
right,
me?
when did you, yes, I can hear you. We shut your video down.
Okay.
When did you make the 1845 payment?
I want to say it had to be Monday because I didn't get off work on Friday or Saturday before the office closed at 5 o'clock. And the
And how
lady that
much
was
did
in
you
the
pay?
office, I gave
I
them
don't
the
care about the lady in
1840.
the office. How much did you pay?
I gave them 1845. That was for last month.
All right.
So I only owe this month.
And so they indicated they wouldn't apply it to your account.
Because it was a partial payment, but they applied it before because the 2045
Okay,
that I
Miss
paid.
Booker, just answer my question. They said they wouldn't apply it to your account, but you're telling me that they haven't.
Yes.
All right, Counsel, you don't know anything about that, right?
Your Honor, I did not receive any that they were holding any payments. if we wanted to pass this matter, I could.
Yeah, I'll pass it. Ms. Booker, I'm gonna pass your case. They're gonna double check with the office as to whether or not they have it.
Okay.
Thank you. Arbor Woods versus Shanton Campbell. And Diane Taylor. Hello,
Hello, how are you?
what's your name?
My name is Shatan Campbell.
All right, what is, how much is owing on this account?
Your Honor, I have rent to retain of $1,707.25. Cost of $242 for a total of $1,949.25.
1,009, say it again, 19.
$1,949.25.
Gotcha. And that was gonna be paid today. Was it? Go ahead, ma'am.
Yes, I prematurely assumed my pay was gonna hit, but it did not. I don't originally get paid till Monday. So I would say on Monday, I could pay $1,650 and I could pay the rest by that Thursday. So I get some money on Wednesday, but I don't want to just say,
Hold on a
I
second.
want to give it that extra.
So
day.
everything's gonna be taken care of by the 19th.
Yes, definitely.
Okay, so here's what I'm gonna do. Obviously, you made that $1,650 payment
Yes, sir.
that you told me you were gonna make. I'm gonna find that there's no tribal issue after hearing in this case. I'm gonna grant them a judgment for possession with the 1949.25, okay?
Okay.
But nothing will happen, no writ will issue until the 22nd. I'll just give you the 10 days, but you're gonna have everything clear.
Yes,
That works for you?
it sure do.
Thank you.
Thank you. Have a great rest of your day.
You prematurely thought somebody was gonna pay you. No, it's okay, go ahead. Take care. Court calls the case of Arbor Woods versus Shakira Lee.
I'm here, Your Honor.
And also, Paige. Ms. Lee?
Yes.
All right, you're there. All right, and what's the current balance on this account?
Your Honor, I have rent to retain of $4,446.88. Cost of $242 for a total of $4,688.88.
All right, Ms. Lee, how are you getting that paid?
That balance doesn't sound like the 15 or 1,600 that I just paid was added to it. But I did speak with the office. She said she's willing to do a payment plan. I just need to come on to court and bring that up with the attorney and I guess go over what that payment plan would look like on the record.
Well, I don't know that I'll go through with the payment plan on the record, because I don't, you don't have confirmation, counsel, that your client's gonna enter into a payment plan with her.
No, Your Honor, I do not. If we wanted to pass this matter as well, I could.
Okay, and we'll
confirmation.
put you into a breakout room if necessary. Miss Lee, I just want to make sure you paid how much?
I paid, I think it was 1,600, but it could have been 15.
Okay, but somewhere between 15 and 1,600 you paid. When did you do that?
On Monday or I don't
I'm
remember.
sorry, say that again. You're breaking up on me. What was that? Yeah, Miss Lee, say that again for me. Hold on, you're really breaking up.
Okay.
Okay, try it again for me.
Okay. So it was paid within this week.
Okay, you just don't know what day.
Yeah, I just don't know what day.
Okay, that's okay. So I'm gonna ask you to hold I'm gonna pass your matter. I'm gonna get through these other cases. They're gonna contact the office and see if we can get something worked out today, okay?
Sounds good. Thank you.
Thank you. Arbor Woods versus Brandon Wilson. And Kimberly Slayton.
Hi.
Okay, there's Miss Slayton. All right. And where are we on her account?
Your Honor, I have rent to retain of $1,614.65, costs of $242, for a total of $1,856.65. So Your Honor, we did receive payment of $4,050 from.
Just like she told me she would. All right. All right. So when are you, how are you intending on getting the balance paid?
I had a death in my family earlier this week of my grandmother. I wanted to make a payment this week, but I can make a payment in full the 26th.
The 26th, you said?
Yes. Yes, sir.
Okay, that's can you pay that early in the day?
Yes.
Okay. Over the objection of plaintiff, and I'm doing it because she told me she was gonna pay $4,000. She did it. I'm gonna give her the benefit of the doubt here. And so I'm gonna adjourn this out 2 weeks, let you get that paid.
Thank you so much.
Okay, so this could be a dismissal. I'll adjourn it to the 26th at 2025 at 2 p.m. Okay?
Okay.
Get that paid, okay?
Thank you, Your Honor.
Okay, don't make me look bad.
I'm not, never. Thank you.
Okay.
Have a good
All
day.
right.
All right, bye-bye.
Thank you. Northfield Estates versus Rose, is it Voljan?
Oh, yeah.
Say again?
Oh, yeah.
Okay, come on up.
Casey Matson for the plaintiff.
State your name again.
Rosemary Foyan.
Okay. And where are we on her account?
Your Honor, I have rent to retain of $2,588.64, costs of $213, for a total of $2,801.64. Your Honor, this time we are at the second hearing, so we would be asking.
I understand.
I have a application into DHS that I'm waiting for a notice from.
I'm sorry?
I have a application at DHS.
Okay. How many people are in your apartment?
Just me.
Okay, but so at most, they're gonna pay $410.
Okay.
So where would the rest of this come from?
I'm working on that.
Okay, what do you mean you're working on that?
I'm filling out other applications and I increased my hours at work.
Okay, but you gotta have a plan for how you're gonna get this paid. And I'm not hearing one.
Well, I keep paying every week. I paid $375 this week. Next week, hopefully I'll be able to pay $400 or $500 with increasing my hours.
Okay, but if you did that every week, it's still gonna leave a balance of probably about 1,800.
And then I was hoping I could work out some kind of payment arrangement.
Have you talked to them about that?
They tell me to come to court. They're the ones that's helped me fill out all the applications and stuff.
Pardon?
They're the ones that's been helping me fill out all the applications.
They who?
The people in the
The
office.
office? Okay, so they were helping you fill out the applications for assistance?
Mm-hmm.
Okay. But have you talked to them about a payment plan at all or anything?
The secretary keeps telling me she don't know. She thinks, but she don't know.
She thinks what? That they'll work with you,
Mm-hmm.
but she doesn't know.
Mm-hmm. So I called Sherry. I called corporate and left a message Tuesday for Sherry to talk to her, and I haven't got a response.
All right. Ms. Matson, you were gonna say something, I'm sorry.
Yes, Your Honor, I did receive direction from my client that at this time they're not willing to enter into payment plans.
Okay. So they're not willing to enter into any payment plan with the family.
Okay, so can I have an adjournment to see what I get from DHS to see what I need to, if I have
I'm
anything to
2
work with?
weeks out effectively,
Mm-hmm.
all right? And you get the 14 days, but we're there now. And so DH, and the bottom line to this, ma'am, is, as I've indicated, DHS will give you $410.
Mm-hmm.
There is then roughly about $2,400 that needs to be paid. And I'm not hearing from you how that's gonna.
Well, my boss told me he would give me 500. My mom and grandma said they would help, but they haven't gave me an amount because they're waiting to see what I need.
Okay.
So I'm still, like I said, I'm still figuring it out.
So here's what I'm gonna do. I'm gonna find that there's no tribal issue after a hearing. And I'm gonna grant a judgment to the plaintiff for possession in that total amount of 280164 or 69 or 64.
64.
Okay. 64. Okay, so I'm gonna grant them a judgment. Normally, you would have to have this taken care of by the 22nd. What I'm gonna do is I'm gonna extend it out a week. I'm gonna give it to the 29th. Okay, over the objection of plaintiff. So I'm gonna give you to the 29th to get it paid. So however you're bringing all of this together,
Mm-hmm.
you're gonna need to make sure they're paid by the 29th.
By the 29th.
Yes, ma'am.
Okay.
Okay.
And
Thank
what
you.
was the total judgment? 28,
280164.
280164. Okay.
All right, thank you.
Thank you.
Northfield Estates versus Jeffrey Costco. Jeffrey Costco, not checked in. You may proceed, counsel.
Your Honor, I do believe there's just a small balance remaining on this account. There's $40 in rent to retain and $40 total remaining.
Yes. Okay. So you want to adjourn it out, see if we can get paid?
Yes, Your Honor, I think that would be best unless you'd be willing to enter a judgment for that amount, but.
That'd be negatory. I won't do that. Let's see if we can get it paid. September 19th, 2025, 1 p.m. Northfield Crossing versus Jessica Bradshaw.
I am here. Hold on 1 second.
Okay. All right. You're trying to turn on your video.
I'm having a hard time hearing you.
You're having a hard time hearing me?
Yeah, unless I put the phone up to my ear for whatever reason.
Okay, let's see if we can get through this then. How much is owing on her account?
Your Honor, I have rent to retain of $1,402.77, cost of $190, for a total of $1,592.77. We did receive the payment of $500 from last week.
That is correct. I did put in the payment for 500.
Okay. And how were you intending on getting the rest of this paid? Well, go ahead. I have another question for you. Go ahead.
That's okay. I did put in for the SER for DHS. I haven't heard anything back from them just
Gotcha.
yet.
Got it. Okay, and so I'll give you the 14 days then from the time you put the SCR in. Let me make sure I do have the assistant form. So I'll give you that. So I'll adjourn it to the 19th at
Okay.
1 PM.
I do have a
And-
question in regards to that. I will be working in the OR that day and I can't switch my schedule, so that is an issue with that. I am shadowing one of the surgeons that day.
Gotcha.
So I'm not sure how to switch with that. It's my turn to do that day. So how do I go about doing that?
So you can't, in other words, you can't zoom into a hearing.
Correct. I will be in the OR.
Gotcha.
And I do get paid next, this coming week, that day as well. So I was going to put money towards it that day as well. I just don't know how much, because I don't know how much I'm gonna get paid that day. Because I don't know if you remember, I was out on leave from having my gallbladder out.
Okay, so let's figure this out. You paid the 500.
Correct.
You're not gonna be available because you'll be in the OR with a surgeon.
Correct.
Got it. And so you have no funds that you can put in between now and then?
Not as of right now, because I just had to pay my mortgage payment and they just took my last $400.
Okay, all right. All right, I'm gonna believe you. And what day do you get paid?
I get
The
paid
19th?
this, whatever next Friday is.
The 19th?
Correct.
Okay, and out of that pay, do you know how much you can pay?
I'm gonna say roughly around, because I don't know how much I'm gonna get paid because I was just off for a whole week. I'm gonna say roughly around $350.
Okay.
And if I can work something out with the office to pay, like on a payment plan to get everything caught up, that would be great. Trust me, having my gallbladder out was not fun and it did set me behind.
All right. Do you know if your client will work with her or not, or?
Your Honor, I do not have the authority to enter into a payment plan today.
Got it. Here's what I'm gonna do. She's got this with work and I can appreciate the fact she can't do that from the OR. It's not like she can step out and do that. So over the objection of plaintiff, I'm gonna adjourn her out to the 26th. She's to pay the $350 by the 19th.
Okay.
Okay. If you get the $350 paid, then whenever I enter the judgment, you'll have the time. If not, then what's gonna happen is I'm going to grant them a judgment as though it were today.
Okay.
Got it? Because I'm giving you
Absolutely.
the extra time because of work.
Absolutely.
All right? Thank
Yep.
you.
Thank you. Bye-bye.
Northville Crossing versus Ardell Carson. They're not checked in. You may proceed, counsel.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $2,075.06. Cost of $190 for a total of $2,265.06 with a writ to issue after September 22nd.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue in 10 days. Northville Crossing versus Justin Hay.
Good afternoon.
Hello, what's your name?
Justin.
All right. And what do you have as his current balance?
Your Honor, I have rent to retain of $1,685.82. Cost of $190 for a total of $1,875.82. Your Honor, defendant was supposed to pay $700, and I
Did they-
haven't received that.
Did you?
So as discussed in the last meeting, I will have that $700 before the park closes. I had to wait for my father to get off work and then I came down here.
So you're gonna pay that today?
Yep.
And, okay, let's assume that you get that paid.
And then I should,
How are you gonna pay the balance of
the
this?
remaining balance should be paid by next week.
By the 19th?
Yep.
Okay, so here's what I'm gonna do. I'm gonna find no tribal issue after a hearing. I'm gonna grant a judgment for possession to the plaintiff in the amount of 1875.82. All right,
Alrighty.
and no writ before the 22nd, which is that following Monday.
Okay.
Okay, so get that one payment in, get the next payment in, and then you'll be good.
Awesome.
All right,
Thank you.
thank you, sir.
Have a good rest of your day.
You do. Court calls the case of Northfield Crossing versus Eugene Ranke. Eugene Ranke. Where in Zoom? Oh, got it.
I'm here, Your
Mr.
Honor.
Ranke?
Yes, sir. How are you?
Okay. I'm doing good. I need a camera, but
Yeah, this.
have you heard from SER yet?
Camera, sir. It's not working.
I am not.
Yeah, the camera is not working, sir.
Okay. Have you heard from the state regarding your assistance?
Not yet, sir. I tried calling, but I couldn't get to speak to anyone. As I said, I started a new job this Monday, and I will be able to pay $700 on the 19th, and I will make payment arrangement at the same time. Try to clear the balance before 30th of this month.
Well, I can't get you to the 30th if you're paying the 700. What I will do is this. I'll extend it out a week, but I'm finding no tribal issue after a hearing. I'll issue a judgment for possession. How much is owing, counsel?
Your Honor, I've entertained of $2,147.16. Cost of $190 for a total of $2,337.16.
All right. I'm going to issue judgment for possession in that amount after a hearing with the writ to issue the 29th. So you need to get all of that paid by that date, sir. All right?
Okay, sir. Thank you.
Thank you. Court calls the case of Northfield Crossing versus Suzanne. Is it Tahovic? Tahovic?
Tahovnik, that's my grandmother.
That's right. Hello.
Hi, how
recall.
are you?
All right. And where are we on this case?
Your Honor, we did submit an amended summons and complaint to name the estate of Suzanne.
Yes, we
and
have that.
Miss Gilden, I'm assuming made significant payments. So the rent to retain is $709.52. Cost of $190 for a total of $899.52.
Hey, ma'am, how are we gonna get that paid?
Well, I'm trying.
No, I know you are. And
I'm tired. I'm sorry.
no, it's okay.
I got physical access to the property only in May. I had an unwanted guest there. So since then, I've been cleaning it up. I thought the park was going to be able to buy it back. A new manager came on, and now they're saying that that might not be an option. I think there's 17 trailers listed for sale right now. I'm trying my best. I thought we had an agreement that if I caught up August plus that they were going to work with me. It seems like we had some miscommunication there. So I am going to pay it. It's just, then you might see me in October because I might be a little late there, right? I don't live there. I have a premium
No, I know.
rate. I think I guess my main question is if the attorney has access to anybody in a higher position that could help guide me, that might be helpful. Because I'm just not sure. I uncover new details all the time. I get information like little by little, right? I'm just really not sure. I don't know.
All right, Ms. Glidden, do me a favor.
Yeah.
Take a deep breath.
I know, sorry.
All right, no, it's okay. It sounds to me like you haven't been able to for a while. All
Yeah.
right? So just take a deep breath. This has gotten paid down to quite a bit here. So the question becomes for me, and then maybe we can figure out who you might talk to. Do you have an indication as to when you might get this paid?
So I paid them on Friday. We have to pay our own mortgage this week. So, I would say next week we would probably be able to make the payment.
You're saying on the 19th, you think?
I believe so. Unfortunately, my husband's not home and we're a one income family, but I believe that's okay.
Okay. All right, and then you're gonna talk to somebody, you're looking at selling, you're looking at trying to stabilize things and figuring out selling this trailer. That's really
Correct.
what's happening.
Correct.
Okay, here's what I'm gonna do. In this case, I'm gonna adjourn this out. I'm just gonna indicate that you're gonna pay the balance. Okay. All right, of this. I'm going to adjourn this out to the 26th because you paid down quite a bit and I get it. You're trying to just get through this part of it, take piece by piece.
The only time we fall behind is when something, crazy happened. We helped my niece get a car and car insurance in the beginning of the year. And we paid up 6 months of her car insurance. And when I went to pay August rent, it didn't go through on the credit card. And that's because they took another 6 months of her insurance off. So
Gotcha.
things like that happen.
Okay. All right. So the 26th at 2 p.m. And then I'd suggest calling the attorney's office, see if they can get you to somebody to talk to try to figure it out for you.
I
Okay?
appreciate that. Thank you so
All
much.
right. You take care and have a great weekend.
Thank you. You too.
And do me a favor. Every time you get on, you stress me out too.
I know.
All right?
I'm sorry.
And there's it's not good for anybody to judge his stress. So take this weekend, take a deep breath, take care of yourself, okay?
I'm trying. Thank you so much.
All right. Take care.
Okay. You too.
Bye-bye.
Bye-bye.
Northville Crossing versus James Worthington and Stevie Worthington. Listen.
I am Stevie Worthington.
You're James Worthington. All right. And counsel, how much do we have owing?
Your Honor, I have entertained of $1,805.00, cost of $246, for a total of $2,051.00.
Okay. Folks, how are we looking at getting this paid?
We're not, unless we can be on a payment plan.
We're attempting to sell the home. We're trying to, our aunt is supposed to take over payments on it and she's gonna list it for sale and
But it's not a for sure thing. We intended on going, we've been paying, we have, been out of the home since December. I emptied it last month. There's some situations. I'm currently living with my father and with our 2 children. He's not allowed at the house. So I'm traumatized by the house, so I'm not allowed, so it's just kind of a whole thing.
Okay.
And it came down to pick or choose, I just got some help from a lady. She's gonna help me fill out emergency food stamps for me and the kids, even though my dad is helping us. I don't want him. But anyways,
No, it's okay.
Life is crazy and I don't know how we're gonna get it, and if I'm up to date on the mortgage of the home because we own the home for almost 11 years now. So I'm up to date on that, but he's staying at a hotel, so we have to pay for that and just everyday stuff, you know, so I'm trying my best.
All right. So let me ask you this. With regard to the home, what are you looking to have happen?
It's empty. I cleaned it up the best that I could. I heard that somebody might have done some stuff inside of it after, but I have not.
You've not been there.
No, all my stuff is out, so there is some
Okay,
garbage in the.
did you own it though, right?
Yeah, we own
So
it.
you can't turn in that car. Counsel?
Your Honor, there could be, they own it outright, there's no lien, no mortgage.
No,
There is
there's I talked to Brittany in the office.
22,000 left on the
Yeah.
mortgage.
22,000?
Yes.
Okay.
I'm not.
You were saying, counsel?
Your Honor, I mean, that does change things a little bit. Is that mortgage would have to be, that would be something that they would have to figure out with their mortgage company. So as for the lot rent, we would still be requesting entry of a judgment. It's, the home does belong to them and it's still on my client's property.
Okay, so you're requesting the judgment, and I think that may be
We're
the
prepared to walk
best.
away from the
Pardon?
mortgage. We're prepared to walk away.
Okay, so there. No, I hear you, and I'm not advising you that I can't, this
Right.
should do.
Right.
But what I'm going to do is I'm going to issue a judgment to the plaintiff after a hearing in this case for the 2051.
May I add something?
Yes.
We paid July. It was very late. So I don't know if that's taken off of the balance or.
How much was that?
800 something, almost $900.
Almost 900
We are behind
in
though.
July?
Yes.
Do
Just
you
like
have
the 26.
about a $900 payment in July?
Yes, towards the end of July, July 27th, I have $887.50.
Is that the one you're talking about, ma'am?
Yes.
Okay, so
believe so.
that's taken off.
Okay.
I just,
So, go ahead.
I just took a injury and it's been hard to keep working and keep going. It was down in my nether regions and it's really difficult to get back to work. And now it's finally picking up. Small business, I get paid at the end of the month, like the money trickles in that last week.
Right.
So I was hoping we could get something together to where we could get balance zeroed out and the house immediately put on the market, but this has just been tough.
Got it. All right, I'll grant a judgment for possession, that full amount. And then a written 10 days. Okay. And then you can figure out what you're gonna do on that, okay?
So it's 10 days.
That would have to be paid in 10 days to keep possession, but you've got options in
Yeah.
some ways because you're not.
We do have somebody that we're hoping that can help us. He's going to buy and donate the home to somebody in need. We did the last thing we could. We donated the appliances to a family in need that lives in that neighborhood.
Okay.
So we tried
Doing the
our
best
best.
we can.
Pardon?
We're doing the best we can.
I know you are. All right. Okay. Okay, I'll enter that judgment. You guys take care of yourselves, please. All right. Take
Yep.
care. Thank you.
So much appreciate it. Have a great day.
You do the same. Northville Crossing versus Jelene Davis
Here.
and Jocelyn Diamond.
Here.
Okay. All right. Who is that? That's Miss Davis.
I'm right here.
And yeah, no, I know. And what's his name? All right. That guy that just keeps showing up with you. All right. Where are we on this case?
Your Honor, we have rent to retain of $1,245.20, cost of $246.00, for a total of $1,491.24. Your Honor, they did pay the $610 last week, but we would still be
Okay.
asking for entry of a judgment today.
All right. Okay, folks, how are you gonna get the rest of this paid?
Well, I did reach out to the manager, Mr. Turner, and Bobby Sprangler emailed me back, and it looks like they're allowing us to make payments.
That's what your email says?
Yes.
Did you have, well, has the amount of the payments been set up or?
We haven't set a definite amount per week, but in the email she said that they'll still need to give us legal notices because even though they're allowing us to make payments.
Got it. I see. So we just don't know what that looks like at this point. Right?
Correct. Yeah.
All right. Here's what I'm gonna do. I'm gonna adjourn it out 1 week. Counsel, I don't know if you were aware of that or not.
I was not, Your Honor.
Okay, so let me adjourn it out 1 week. I'll adjourn this out to September 19th, 2025 at what time? At 1 p.m. Okay? Allow
Okay.
counsel to check into that and see whether or not that can work out. All right. What did he say?
Who, me?
Yeah.
I'll learn my lesson, sir. I didn't say anything
I
unless
said,
I'm
no,
spoken
you
to.
can go ahead and talk. I'm not listening, but you can talk.
No, everything she said was true. I'm working on some things now. I'm trying to for the next 2 Fridays in a row give them about $600, and then I got some other money coming in so we can balance out by the end of the month.
Okay, so if you do something this Friday, I don't know if you can, but if you do something this Friday and the next Friday, your balance is gonna be very, very low.
Right.
And you may be able to get.
I can't do anything as of this Friday, like today, but I'm trying to make a payment by Tuesday and then make another payment by like next Friday or by next Friday.
Oh, gotcha. Okay. So see what you can do. Let counsel check into the payment plan, and then we'll figure out exactly where we are next week. Fair enough?
Okay.
Yes, sir.
Yes, thank
Yes, sir.
you.
Thank
Is that good with, hold on. Is that good with you, Ms. Davis?
Yes, thank you.
Okay, that's all I care about. All right, thank you. Spice Tree Apartments versus Kia Berry. Hello,
Hi,
what's your name?
Kia Berry.
All right, and where are we on this?
Your Honor, I have rent to retain of $1,595.92, cost of $169, for a total of $1,764.92.
Ms. Berry paid about 800 or so.
I paid 900 on the 3rd,
Yeah.
and then I paid 500 this morning.
So you paid another 5
Yes.
this morning, so you're at about the 12. And how are you planning on getting the rest paid?
I get paid on Wednesday, so I was hoping I can at least get everything paid by the 19th.
By the 19th, you think you can get everything paid?
I hope so. I did apply for an SER, so.
All right.
So.
But you know what? You paid this down. So what I'm gonna do over the objection of plaintiff, maybe she has an SER pending, so. I'll adjourn this out to the 19th, 2025, 1 p.m. At 1 p.m.
Okay.
And how much can you be assured that you'll get paid by that date?
I want to try to pay the whole thing, the whole 1,700.
Okay. I'm writing it down.
Okay,
Okay.
I'll make sure.
All right, very good. If you have everything paid, I don't need to see you.
Okay.
But you just have to make sure everything's.
Everything's paid for. Okay.
All right.
All right. Thank you so
Take
much.
care. Court calls case, Spice Street Apartment versus Brian Meeks. Oh, there he is. Okay, you're usually, okay. And what's the balance currently?
Your Honor, the balance is, I'm sorry, the rent to retain is $3,260.74. Cost of $182 for a total of $3,442.74. We are asking for entry of a judgment, since no payments were made since the last hearing.
Yes. All right, sir. Yes. How are you intending on getting this paid? Remember your circumstances and how you work. I get it.
So, yes, sir. So I have finally, I got this one guy in closing. It's in final underwriting. My check will be about $4,800. So I'll be able to just pay the full balance then. It should be closing this coming week. Should be. I mean, but it's an underwriting. I've been.
No, I got you.
Texting.
I got you. So here's what I'm gonna do, because I think the last time we were here, you came through on everything. It's just.
Oh, yeah.
Had somebody, yeah. You had to wait on other people to do what it's
real estate commissions.
So I will find that there's no tribal issue. I'll issue a judgment after hearing for possession for that total amount of 3442. Was it 74?
Yes, Your Honor.
I don't know why I can't read my writing today. All right. For that amount, I will, because the closing is supposed to take place next week, but who knows? The writ date will be the 29th.
Thank you. Thank you.
All right. And he'll get that paid, I'm sure. All right.
Thank you, Your Honor.
Thank you, sir. Court calls case of Scioto Farms versus Melanie Clemens. Is she on the? Oh, she is. Hello, Ms. Clemens.
Hello.
All right. What's the current balance on her account?
Your Honor, I have rent to retain of 4,000, I'm sorry, not 4,000. Rent to retain of $424.82. Cost of $190 for a total of $614.82.
It's okay. All right, Ms. Clemens, you told me you were gonna pay, you did? How are you gonna get the rest of this done, ma'am?
Still got something out, waiting something from Peace Neighborhood, but I won't know about that till next week. But if not, I can pay on the 19th. Second, how did it go up to $600 and some dollars? Well, it should have been $5. According to the, it was $2,039.82. $1,500 got paid. How did it go to $6 something? It should have been $534.
Hold on. Hold on. Ms. Clemens.
Okay.
You want to yell at me, don't you?
No, not you. I'm not yelling at you. No.
No, you're not. You're yelling at other people?
Nobody. No, I'm not yelling. It's just that my phone is so low. I'm sorry. I'm sorry if I'm talking loud. My phone, I can barely hear you, so it's making me talk loud. I'm sorry.
Oh, okay. All right. I get it. So, because my feelings were getting hurt.
Oh, no.
Okay. Was there a late fee that got included, counsel?
Yes, there was, Your Honor, a $55 late fee.
That's what happened, Ms. Clemens.
Okay. So what is the balance again now?
$614.82.
I can pay it in the afternoon on the 19th.
How late on the afternoon on the 19th?
I think my check posts anywhere between 12 and 1 o'clock, somewhere in there.
Is my time 1 o'clock on this?
Yeah.
Oh, that's okay though, but you can get that paid and Patty will be here so she can tell us. So, all
And
right.
and if Peace Neighborhood Center comes through sooner, it'll be paid sooner, but.
Okay, Ms. Clemens, here's what I'll do. I'm gonna adjourn it out 1 week to the 19th, 2025 at 1 p.m. And then you should have that paid, and then we can dismiss the case and you can quit yelling at me. Okay.
The question
All
for
right, Ms.
you.
All right,
If
Ms.
pay the
Clemens, you.
619 I can barely, sorry, I don't know what's wrong. If I pay the 619th on the 19th, do I still need to come to court?
No, you don't need to be here. I'll miss you,
Okay.
but you don't need to come. Okay.
All right.
All right, Ms. Clemens, you take care.
Thanks. You too. Bye-bye.
Right. Scio Farms versus Eric Jackson. Here it is. Your name, sir?
Eric Jackson.
All right. And how much is owing on Mr. Jackson's account?
Your Honor, I have rent to retain of $1,765.04, cost of $190.00, for a total of $1,955.04. Your Honor, he did pay the $1,400 last week.
Yep.
But we would be requesting entry of judgment today.
All right. Sir, how are you gonna get the rest of this paid?
I'm working on that, actually. I told him I'd have it in by what, the 19th.
Pardon?
I said I'd have it paid by the 19th, last Friday when we had court.
Yes, you did.
I was gonna say, I'm actually kind of working on that right now. I'm still on
So
unemployment.
you think you can get it paid by the 19th?
I'm hoping so, if possible. I was gonna see if I could get another week added, because I mean, I'm unemployed.
Gotcha.
now.
Okay, so here's what I'll do. I'll grant a judgment to the plaintiff for possession, finding no tribal issue after a hearing. I will issue the judgment in the amount of the 1955.04 with a writ to issue. I'll extend, since he made a good faith payment, I'll extend his writ to the 29th.
Thank you.
All right, so get that all paid and then you'll be set.
All right.
All right, take
Thank
care. Scio Farms versus Michael Moore. Hello.
Hi.
Your name?
Michael Moore.
All right. And what is the balance that's owed?
Your Honor, we did receive another payment which is not included in this amount. But the rent to retain is $2,211.73. Cost of $190 for a total of $2,401.73. Your Honor, my client did receive an additional payment of $285 right before.
Gotcha. All right. Okay. How are you intending on getting this paid?
I had an unexpected car issue, so I haven't been able to get back and forth to work as easily as I normally do. And I've been doing DoorDash as well. So the car's getting fixed on Monday. I can probably make another $200 payment today or tomorrow.
Okay.
And probably have the rest by the 29th.
You think you can have everything by the 29th?
I think so.
Here's what I'll do. I'll issue a judgment finding no tribal issue after a hearing for the full amount of the 2401.73, understanding that there's that other payment that's there that's going to lower that amount, but I'm not including it.
Right.
Follow me? All right. With the writ to issue the 29th. Give you another week out.
Thank you.
All right. Your car broke down.
Yes.
What kind of car is it?
A Ford Escape, brakes, rotors,
Ford?
and
A Ford broke?
yeah.
Oh, I don't want to talk to you. All right, you must have done something. All right, take care. Scio Farms versus Gregory Pennington.
There, Your Honor.
Okay, there you are, Mr. Pennington. I'll need a camera, but while you work on that, what's the claim in this case?
Your Honor, I have rent to retain of $1,895.55. cost of $190 for a total of $2,088.55. Your Honor, we would be asking for entry of a judgment today. He did make the $600 payment.
Yes, he did. All right, Mr. Pennington, you were working with your 401k. Where are you with that?
I just received the check today, Your Honor. I gotta go cash it. 'Cause I don't have a bank account, so I go to the store and cash it. But other than that, yes, I received it just today. And after I get out
All
of
right.
work, I want to get that cash.
And that's enough to take care of your entire balance.
No, because it's only my check is because the summons I got ordered to or whatever, it was $1,921.16, I do believe. And when you get to do the hardship, that's all you can only do what it calls for. But I am going to because I talked to my people in the 401k because they take taxes out and everything. So he kind of helped me out. He helped me out by calculating how much taxes get, so I can get the exact 1921.16. So I got that, and I'm going to add into $2,000 a day. I'm going to give them, and then next Thursday I was going to give it, I guess, what, $88, I do believe.
Okay, so hold on a second, Mr. Pennington. You're going to pay him $2,000 today.
Correct.
All right. And then you can come up with that other 88 by the 19th.
Yeah, I'm gonna try to work on it today. Like you said, I'd like to get everything paid.
I
at
got
once.
you. Okay.
But if not,
All right.
Thursdays I get paid, so I haven't paid Thursday if not.
Okay, so here's what I'm gonna do. I'm just gonna give him an adjournment to the 19th. He told us exactly what he was gonna do. He paid the money. He got his 401k. He's gonna pay that. He'll be about 88 short, but by that date, he'll get it paid. Then if you get it all paid, I don't need to see you on the 19th. They're gonna dismiss the case, okay? I'll give you a shot at it.
Copy
All
that. I
right.
appreciate that.
Not a problem. Take care, Mr. Pennington.
You too.